Hi, everyone. Good evening. Carl Steinbeck here. Going to cover some more of the Commonwealth of Massachusetts versus Karen Reed murder case out there in Denham, Massachusetts, in the Norfolk County Courthouse. And I'm going to cover some more of day 28, which is last Friday, and which is, I guess, yesterday. So didn't get through anything beyond the direct examination that Alan Jackson did on Dr. Dan Wolfe from the firm of ARCA, which does accident reconstruction, expert testimony, and they do all kinds of testing. So we actually saw real highly qualified engineering tests done by ARCA, unlike what we saw from the Commonwealth, who has a burden of proof here. So they had nothing but some kind of joke. It's an absolute joke of a so-called test that they paid almost $400,000 for, which is basically nothing other than somebody buying a Lexus, the exact same kind that Karen Reed had, and slapping some paint on the corner taillight and then backing up 2 miles an hour and bumping their PhD engineer guy away from the car. And that was the extent of their test. There was no sensors. There was no actual dummy test where they could really speed it up and see what kind of damage that was done to the Lexus in question. There was no interval changes of speeds to see the kind of damage done to both the taillight as well as the arm of the dummy, which would replicate whatever supposedly would have happened to John O'Keefe if he was struck by a vehicle. So we've already seen from direct examination here of Dr. Wolfe that I covered last night that there's no way that this vehicle of Karen struck John O'Keefe. So let's see now what the prosecutor on the case, Hank Brennan, has now for him trying to cross-examine this Dr. Wolfe. And as we know from history here, the way Brennan conducts his cross-examination is he's going to get down and ugly with the witness and just go on ad nauseum, trying to trip him up and really browbeating him and being a bully. And as I've said all along, if you have a prosecutor that's a bully and a tyrant towards witnesses, they will lose the case. And that's exactly what we're seeing here now. And we also heard from a number of you commenting last night how the DUI guy, Larry Foreman, was there visiting for one day. He was able to get in as a media rep on this case. And he was saying the jury pretty much wanted to see everything that Dr. Wolfe had to testify on direct. And then when the bully got up to do the cross-examination, the jurors pretty much checked out, stopped taking notes. And a lot of them made faces of disgusted annoyance and stuff like that with a lot of his objections and stuff like that on the direct examination as well. So I would say that that aligns with what I was expecting a jury to view the prosecution on this case so far. I've been saying that for weeks now, that the case is game over, that the prosecution has lost all credibility. And if you don't have credibility as a prosecutor, that is paramount, and it is basically fatal to your case if the jury doesn't trust you, and especially if the jury doesn't like you and you're coming across like a bully. So we got a lot of younger folks on there. They have less tolerance of bullying than older generations. So the average age of the jurors is around 30, 31. So they're not gonna like this guy, and they don't want to listen to what he says. And they're already through rolling of the eyes and gas and stuff like that. They already are sick and tired of seeing what this Brennan guy does to witnesses. So let's go ahead and jump right into it, and we'll see some more of the par for the course here for this.
So jurors, we are going to stop today at 3:45. All right, Mr. Brennan.
Thank you, Your Honor.
Sure sounds.
All right, so, okay, great. Thank you. All right, do we have the actual? Okay, great. Yep. So.
Exhibit 216.
Thank you. All right, Mr. Brennan.
Good afternoon, Dr. Wolfe.
Good afternoon.
Wouldn't you?
Let's see how many times he says Dr. Wolfe on his cross-examination. I don't think he's ever going to say the Wolfe word again. How often will he even say doctor?
You testified in direct. You shared with the jury some of the work that ARCA does. Do you remember that?
Yes.
And you had mentioned a couple interesting things, that there had been some work with the Department of Defense.
Correct. Yes.
The work with the Department of Defense, was that during your time or before you got there?
That would have been prior to my employment. Yes.
So when you were telling them about working with the Department of Defense, that really had nothing to do with you. That was ARCA before you began working there.
ARCA as a whole, yes. The work that we do, yes.
Not you.
As I said, I wasn't involved specifically in that project, no.
And you mentioned that you did some stuff, or the company does some things for the NHL.
Yes.
You didn't tell us much more about what you do. There's other things that ARCA does as far as clients, right?
Certainly.
Did you share with us that you work for lawyers and law firms?
Yes, we do.
And you do litigation, insurance companies?
Yes.
Okay. Is there any reason why you highlighted the Department of Defense that you don't do, and the NHL, but didn't share the rest of the stuff with us?
You know what? This would be the perfect opportunity to say, well, just like I'm not able to talk about how the FBI hired us on this case, I would have, if I was him, I would have been like, that's my opportunity, that's my window. And
That's just some of the prominent clients that we have.
I see. You provided us a
why wouldn't you just say FBI in general? I bet you as a prosecutor kept this out. That's how corrupt this whole process is.
CV, didn't you?
Unbelievable.
Yes.
And that's like a resume, tells us a little bit about your education experience. You get to highlight some of the things, your accomplishments.
Yes.
You shared with us you've been the director of accident reconstruction at this company, ARCA, since 2017.
No, not since I started.
You started with ARCA in 2017.
Correct, yes.
When did you become the director of accident reconstruction?
I think that would have been in January of 2024, so about a year and a half.
About a year and a half ago?
Yes.
And you received your certification from ACTAR.
Yes.
Did you pass the test on both parts first time?
I don't recall if it, I think it was I had to retake, I think, the practical section in the afternoon.
Look at that. He's just trying to dig anything he possibly can. A test that he's passed, he's going to bring up the fact that one portion he didn't pass in one time. And yet you bring forward a guy that lies for many years about his bachelor's degree he never had, and he wasn't even working towards it. So he got away with the lie, Burgess did, that he wasn't even working towards it since 2019. So it was it's just a night and day difference between the qualifications, and how this guy is trying to scam the jury is just outrageous.
Well, you would recall something like that, wouldn't you? Did you pass both parts on the first try?
Like I said, I think it was the second part I had to retake.
Well, this is a pretty important test, isn't it?
Not really.
It's your certification.
It is, but much of the concepts that are covered in it are very elementary.
Well, not so elementary. You had a hard time with part of it.
What a smart Alec here. My gosh. So like a test is really going to educate you on whether you're going to be good or bad in your job. A test is just a rite of passage. And so if you study enough for it, you can pass it, and you can easily have some reason that you read something wrong and miss a few answers. So, and some people just aren't good test takers. If anyway, what else is going on?
Well, with respect to the portion that I had to retake, it's a practical exam where you have to reconstruct an accident, where you have to determine approach angles, departure angles, and it can be very sensitive to those inputs. And unfortunately, if you mess up one of your first angles and you carry out that calculation, then the whole problem is graded wrong, even if you did all of the math correct.
So we understand there's a multiple choice question part that's the easier part, correct?
I don't know if it's easier, but there is a multiple choice part.
There's a more practical part where you actually have to go out in the field and do assessments, kind of like the things that you did today.
You don't go out into the field, no.
And, when did you first take that second part that you didn't pass?
I don't recall.
You don't remember when you took the test?
No, I don't.
Suffice to say, you took it again.
Correct.
And ultimately, you passed both sections of that test?
Yes.
In your CV, you list your schooling. And you list your degrees, don't you?
Yes.
You mentioned some of the things that you focused on in your academic experience, don't you?
Yes.
And you have publications.
Correct.
Recently, you did a publication regarding vehicle control history on Toyotas.
Correct.
Vehicle control history is data that is stored in a vehicle,
Yes.
and Toyota owns Lexus, correct?
Correct.
So you have familiarity with vehicle control history. In fact, you have a publication on it.
Yes.
Yeah, Sharon McCarthy, the dirty of Hank to bring up insurance knowing a prior juror thought that, or multiple jurors thought that ARCA was doing insurance and trying to defend Karen and avoid paying claims. So that's what I believe the cop on the jury was able to bamboozle the other jurors with. So, and for him to bring this up, knowing that he's blocked and this judge is blocking the truth that FBI hired him, it just shows you how corrupt and dirty this whole process is. So I just, I just wish there's a way they would have said, I think you're opening a door to who really hired us to do something if he doesn't want to say FBI. But why wouldn't he just say that their clients routinely include law enforcement or have included law enforcement without saying it was for this case? But again, the jurors, I believe they hopefully are getting it now that the feds were the ones that hired him to do this, because they're going to think, how did the defense go so late in the game they couldn't hire him until just a few months ago?
In your entire resume, you only mentioned pedestrian collisions, or that you're involved in pedestrian type events 3 times. Is there anything specific in your resume or your publications that show a published accomplishment, for example, in pedestrian collisions? Do you have any publications that have been peer reviewed or published in that area?
No, I don't have any publications in pedestrians.
You write or you note areas of specialty, and you list a bunch: accident reconstruction, human factors, EDR, commercial vehicle, HVEDR, pedestrian bicycle accidents, nighttime visibility, and a number of others, correct?
Correct.
Is there anywhere in your resume that notes particular classes that you've attended and completed regarding pedestrian collisions?
No, I haven't taken any classes in that.
You haven't taken any classes on pedestrian collisions?
No.
Have you ever taught regarding pedestrian collisions?
No.
Have you ever been a speaker in a presentation about pedestrian collisions?
Yes.
Okay. Is that listed in your resume?
I don't list lectures or presentations, no.
You were asked questions about your involvement in this case. Yes?
Yes.
And you had shared with us that you, at the beginning, were working for a separate party or a third party, you said?
Yes, another agency.
Another agency.
Good, he
And
said
at
agency
some
at
point,
least.
You came into court and testified last year.
Yes.
Hopefully the jury understands an agency means not an insurance agency, but a federal agency.
During the time before you came in and testified, you weren't holding.
I wish you would have said government agency. That would have been better, but
Independent of the defense, were you?
Well, certainly before all of our testing, at the point at which we did all of our testing, report, and analysis, as I mentioned on direct, I didn't know the Commonwealth or the defense in this case.
My question, more precisely, before you testified,
just the way he says this is so snarky, just so cringy to just listen to the way he talks to people. I've never heard a voice that's more irritating. Sorry.
before you came into court and gave your testimony, you weren't totally independent from the defense, were you?
No, I mean, I had to communicate with them to be able to determine when to appear for testimony.
So you were communicating with them, yes?
Yes.
And in fact, some of the time that you spent, ARCA actually built the defense for, and they paid that bill, didn't they?
Eventually, after the trial, yes.
During that time, you know what a sequestration order is, don't you?
Yes.
Do you think that you're under a sequestration order today?
Yes.
Did you talk to anybody about any of the prior testimony in this case before today?
No.
How'd you get here today?
How did I get here today? I took a car ride over from the hotel.
Who drove you?
It was a driver. I don't know his name.
Who set up the car?
It would have been someone on the defense team.
Was it like a window, like a limo?
It was an SUV.
Was there anybody from the defense with you on the ride over?
And when he's having to go up to who drove you to the courthouse and all that, it just shows you how desperate he is. He's got nothing here. He's in the tank. You got a loser case, Brennan. Give it up.
There were 3 young ladies in the back seat. I think they might have been interns, and Mr. Woke.
And who?
Mr. Wolke, I think is it pronounced? Am I saying it wrong?
Have you discussed anything about this case before your testimony today as far as the trial?
Before today?
Yes.
Yes.
Have you discussed anybody's testimony in this case?
Nobody's testimony, no.
That was different last year, though, because before you testified last year, you did have discussions about testimony, didn't you?
Not with the Commonwealth or the defense, no.
But I'm asking, though, you did have discussions about testimony before you testified last year, right?
Correct, yes.
And you know what a sequestration order is, don't you?
Yes.
Funny, Brennan keeps talking about sequestration order, and yet he's the one calling in the middle of the trial back to Burgess of Aperture and telling them to change their reports, which is not allowed under Rule 14. But he gets away with it because you got a judge that's complicit in this hide in the ball game. So everything he's accusing somebody else of doing or trying to accuse or insinuate, he's just blatantly doing it and getting away with it. But I should add that witnesses can talk to attorneys. They're always allowed to talk to the attorney of either side. So that's not even a sequestration order violation. So anyway, again, it's smoke and mirrors. I don't know why the defense doesn't bring that out, that he's trying to trick the witness and bamboozle the jury with this misdirection.
After you testified last year, the court ordered you to provide all of your text messages, all your communications with the defense, didn't they?
Yes, earlier this year.
And when you were ordered to provide all of the actual...
So he's saying ordered like you were ordered because you're not a credible source. You've been hiding stuff. The court ordered you. It's just so despicable to see.
Provide those communications?
Yes, all of the records that I had at the time I provided.
Well, not the records. You know what I'm getting at. Did you provide the communications?
I provided everything I had in my possession, sir.
A text message isn't just a time and date. It's actually substance when you text somebody, isn't there?
Correct.
And when you texted, how many texts do you think you had with the defense?
From what I recall, I think it was around 50 texts that I sent.
It wasn't 100, I think it was 50.
Well, I think it was around 100 total in terms of back and forth, but it was, I think, 50 that I sent.
And during those texts, communications, conversations, correct?
About logistics.
I agree with you, Coffee Cake. Most irritating person. I wouldn't say just man, person, period.
Yes.
Did you provide the content of those text messages when you were ordered to by the court?
Well, those text messages spanned from, I guess it would have been April or so of 2024 through May to June of 2024. Ultimately, I think I received the court's order in May of this year, April of this year. So it was a year after the fact, and I had already deleted the text at that point.
How many of those text messages did you delete?
I just swiped the conversation, so it would have been the whole conversation.
Not how you did it. How many of those 100 or so text messages did you delete, sir?
It would have been the whole text chain. I didn't individually delete them. It just, when you swipe, it just deletes the text chain.
After you deleted them, did you go into the recently deleted and then delete them so they were unavailable?
I don't recall doing that.
Well, you were asked to search your records for the text messages. Did you do a thorough search to see if you still had them or whether you had destroyed them all?
I checked my phone, and I also checked with my phone carrier.
So do you know if they were still under the recently deleted part of your phone, or did you go and take that extra step and totally destroy them?
From what I recall, I did not find any of the text messages, no.
Is there any reason why you deleted all of your text communications with the defense?
Well, it's something that I routinely do. I work with attorneys and clients all the time, whether it's appearing for trial or inspections, and I don't have a habit of keeping a text chain that talks about logistics and things. It's just I routinely delete them after that communication is over with, and certainly after the prior proceeding, once it had concluded, there was no reason for me to preserve those.
Okay. And so, at some point, you switched from text messages to another form of communication, didn't you?
Yes, earlier this year.
Tell us a little bit about this new form of communication, not text messages.
So Mr. Jackson had indicated that he and his defense team utilized an application known as Signal for their communications amongst their defense team. Ultimately asked if I would also use that application to communicate, which I agreed to.
Is Signal an encrypted app?
It's a secure encrypted app, yes.
It doesn't leave any records, right?
I don't believe so, no.
Well, you have it. You're using it. Do you have any records from your Signal use?
What a smart aleck.
I don't know
Wow.
that.
Do you have?
I'll allow that. Yeah, you know what? The FBI has actually warned folks to use encrypted messaging such as Signal, as well as CISA, which is the Computer Security and Information Security Agency of the United States. They tell folks also your regular emails are not safe, so you need to use some kind of encryption like this. So defense is doing something that actually attorneys are supposed to do also with regard to sensitive communications for their clients' files. So they're actually doing the right thing here, and Brennan knows it, but what he's doing is trying to put a spin on this and act like there's something shady or corrupt because of messages. And most of the messages, as he testified earlier in this bogus voir dire the judge made him do, he was saying that it had to do with logistics and things of that nature. It wasn't substantive stuff that they were talking about.
Have any records from your Signal use?
I do not, no.
So you know full well that Signal as an encrypted app leaves no record.
There may be a second.
So you know full well. I mean, just the way he is throwing all these loaded, just knife twisting, like "I gotcha" type comments. It's just so nauseating to see. The attorneys that act that way turn off jurors, and he doesn't even know that. He doesn't even know that the jury cannot stand him.
Setting that you can change. I just know that the way that it was set up, there was no record.
Well, who set yours up to have no record?
I don't know. I think it was default.
Have you ever checked your Signal app to see if you have any record of your communications pursuant to that court order?
Well, I don't have the application anymore, but at the time I did check the application.
Out of all these clients that you've had, how many times or how many clients would you use Signal with?
This was the first time.
Have you used it since with other clients?
Not yet, no.
Before you testified last time, at the last proceeding, or should I say when you testified at the last proceeding, kind of like today, you attempted to portray yourself as totally independent, didn't you?
Attempted to portray yourself as totally independent. Right there, this should open the door to FBI. The defense should be jumping all over this.
Sustained in that.
When you testified,
No objection, sidebar, and this allows him, even putting the question out there, should mandate that this opens the door to bringing up the FBI.
at the prior proceeding, did you attempt to portray yourself as totally independent?
Attempting to portray yourself right there, it's a loaded question, making it look like this guy is got some calculating, scheming, sleazy motives behind him, and that he's an actual snake. So this is like so unbelievably corrupted type of trial. No judge would allow this kind of stuff to go on in a real court in America, but there you got it, because it's all rigged. The whole system is rigged.
Yes.
The truth is, before you testified, you were communicating with the defense and attempting the best you could to assist their cause, weren't you?
I wouldn't characterize it that way.
Oh my gosh, this guy. They just did it because the FBI called him to do it. And see, what he's doing is making it look like they're hired by the defense to create something to appease the defense, not to do justice and call it a spade and balls and strikes as they are. So it's just
So
a hard
before you
watch.
testified, you wrote out questions that you thought could help, that you should be asked when you testified, correct?
So something I routinely do before testifying is prepare an outline of topics and questions that would best help be able to get out my opinions and the analysis I undertook, ultimately so that you all have an understanding of what I did.
So I'm asking you a question. You gave the explanation, but you're skipping over the answer to my question. So
Sustained.
I'll ask.
So see, he can get away with talking and commenting and making these snarky comments. I gotta back that up, even though I can't stand to listen to this guy. Listen to this.
So something I routinely do before testifying is prepare an outline of topics and questions that would best help be able to get out my opinions and the analysis I undertook, ultimately so that you all have an understanding of what I did.
So I'm asking you a question. You gave the explanation, but you're skipping over the answer to my question.
Look at that. Look at that. I've never seen an attorney act so disgusting before. Because you turn off the jurors when you do this. You look like a bully and a tyrant, and they will not want to vote for your cause.
So
Sustained.
I'll ask you again. Before you testified, did you write out a list of questions that you wanted to be asked?
Yes.
And you know what? That's routinely done. But him trying to be a weasel about this is trying to make it look like that's unethical. It's shady. They're hiding the ball and they're trying to trick the jury. Yes, Salem Spank. Why didn't the defense demand all Hank's communication with Welcher and Burgess after what they pulled? They hopefully did that under the Rule 14, but who knows? We don't get to see everything the defense has received from these this slimy DA's office.
And when you listed out the questions, you also listed out the answers, didn't you?
A general response. It wouldn't be verbatim to that.
I didn't say verbatim, but did you list out the answers to each and every one of the questions that you had prepared?
Yes.
So for every question, there's an answer that you provided so that you could follow a script, so to speak, yes?
Can't hear him.
I wouldn't characterize it as a script.
One of the questions asks, so not being able to inspect vehicles is something that is not uncommon in your line of work? And your answer, absolutely not. Remember writing that out?
Yes.
Then you put a footnote, a comment. And you said, not sure if you want to put this somewhere in the direct examination. I have a feeling they are going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. If you need to show the jury, it doesn't matter in this case. Did you write that?
Yes.
When you're talking about they, I have a feeling they are going to argue I didn't personally inspect the vehicle. Who's they?
That'd be the Commonwealth.
Yeah, as far as Signal, do you know that not all, but the highest levels of the administration use Signal because it's encrypted and they can't use regular emails to talk about a lot of government business. So the whole thing that this is underhanded, sneaky, it's sort of like a criminal's way of communicating is
And so when you were writing out these
not
questions
accurate.
as your routine with the answers, is this the mark of independence to you?
Well, I think, again, whether the Commonwealth asked me that question or the defense asked me that question, my response would be the same. It wouldn't change depending on who called me to testify. There are a number of cases, by the time I get involved, the evidence is gone from the roadway, the vehicle is gone. So it's certainly not necessary to inspect a vehicle. And I wanted the jury to have an understanding that because I didn't physically inspect the vehicle, it didn't affect my analysis in the case.
So you think that showed independence?
Yes.
Then you also had another question. Would it be fair to say that because you do a lot of nighttime visibility work, your cases frequently involve pedestrians? Remember that?
Yes.
And you said, yes, unfortunately, there is a direct correlation between time of day and pedestrian fatalities. Is that true?
Correct. Yes.
And do they happen more often in the day or at night?
More often at night. Yes.
Statistically speaking, by the way, this case involves nighttime, doesn't it?
Correct.
Statistically speaking, most of pedestrian fatalities occur during the evening and night hours. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Did you write that?
Yes.
In fact, you testified, you shared that with the jury, didn't you?
Correct. I've testified to that twice last year as well as this year.
And in the notes that you wrote, when you shared it last year and this year, was it an important point to the jury?
I think so, because it helped gave them an understanding, I think, of my background and lighting and human factors. And as I mentioned earlier today, there's a direct correlation between time of day and pedestrian impacts, right? So my specialty in lighting and human factors results in me seeing many, many different types of pedestrian impacts.
So if it's important, why did you include a note? If you don't want me to say this, that's fine. Why did you include a note to the defense that if they didn't want you to say something that you thought was important, you would leave it out?
Well, I think because
It's just so misleading. He can answer it.
I
here.
didn't want to confuse the jury about a statistic that just because we have inclement weather and dark lighting conditions, it doesn't automatically equal a pedestrian impact, right? We have to look at the evidence and the damage to the vehicle and the injuries to determine whether or not a collision occurred, not the visibility.
So you weren't trying to mislead the jury, you were trying to help them because they wouldn't understand something
Yeah, he's really going to get business being a trickster, shyster, right? He really needs a business that bad.
that you were trying to explain? Is that the way you're phrasing this?
I think at the end of the day, it was to help them understand my background, how it relates to seeing a lot of pedestrian impacts.
Something was important that helps the jury get to the truth. Why would you offer to leave it out?
Well, I didn't leave it out.
No, but you offered to. You would have if requested. Why did you
Well-
invite, excuse me, why did you invite somebody else to interject in your independence and guide you to leave something out? Why would you even provide that invitation to them?
Again, it's because I didn't want them to get hung up on a statistic that just because we have more pedestrian impacts at night and in bad weather, that this alleged incident happened at night under bad weather, to give it more weight, to weight the evidence more because of that statistic.
You done?
Yes.
If you make a mistake in court under oath, would you take the affirmative step on your own and correct that mistake?
I'll allow it.
I would do my best to do that, yes.
She wouldn't allow it if the defense ever asked that.
Well, when you say do your best, would you do that if you became aware of it?
I'm going to allow it.
Yes.
Before you testified in a proceeding last year, there was a hearing that you testified in front of Her Honor and other people that were here, correct?
Correct.
I wasn't here.
No.
You were.
Yes.
And you testified about your experience, didn't you?
Correct.
When you were
Yes.
sharing your experience with the court, it was important for the court to have an accurate understanding of what your experience was because it was being evaluated in that hearing, wasn't it?
Correct.
When you testified to the court, you testified that you had been qualified as an expert to testify over 20 times, didn't you?
I don't have the transcript. I believe I said approximately 20 times.
The reality is you hadn't. You've only testified and been qualified 11 times at that point.
Correct. I misunderstood the question. I thought it it also encompassed deposition. So I added those two and approximated at 20.
And at some point when you realized you had made a mistake in your testimony to the court, you had a chance to come back when you testified last year and fix it and clarify the record, didn't you?
Correct, which is why I provided a comment with the specific breakdown for clarification.
And when you came back and testified under oath the second time, on the record under oath, did you clarify and fix?
You know, on the record under oath, that's what he does when he's trying to imply that I got you as a liar and I'm going to pin you down and you misled then. I can show that you're a kind of guy that just doesn't tell the truth when you're sworn to under penalty of perjury and all this kind of stuff. And it's just to talk to a professional guy like this with those kind of terms, it's just so much something that's going to throw off the jury. So that's what I got to be thankful for, is that the jury sees the light. They see the truth of what's going on. And we did hear, as I said in the beginning of this live stream, that the jurors are completely turned off by Brennan, the way he treated him. They stopped taking notes when Brennan was on cross-examination here. And so I think it's just so obvious. You cannot win a criminal case or even a civil case when you come across as an actual bully and tyrant as a lawyer.
Mistaken testimony that you had provided just days earlier.
I don't recall being asked a question. No.
It wasn't whether you're being asked. The question is, did you take the affirmative step to fix the misstatements under oath that you made? Objection.
They're not misstatements. He said how many times you testified. Well, that could include depositions. Testified where? They didn't ask where, and then was clarified, well, trial versus non-trial. And he said about around 20, and it was like 18 or 19. Who cares if he's off a couple? But that's the kind of thing that Brennan tries to feed on when he has nothing else to go on.
Sure.
Yeah, approach, because you're getting railroaded again. Day in, day out, hour after hour. It's a railroad job by the government and the judge. Yeah, Jenny makes himself so unlikable. I don't know. I guess that's why Morrissey thought he could hire this guy to win this case, that he would leave no stone unturned, including the bully tactics to try to bring down Kieran Reed. But the bottom line is jurors do not like attorneys that act this way. So he's just not going to win, folks. He's not going to win. Let me jump ahead here.
After your first testimony, you appreciated that you made a statement under oath that was wrong, didn't you?
Yes.
In fact, you made a note. I realized in my testimony I said about 20 times, when you asked me how many times I'd been qualified, I misinterpreted your question, which was my fault, but in looking at my D&T list,
He on his own volunteers this, but yet Brennan's going to try to skewer him over this, and yet he's the one that brings in Burgess. Keep in mind, Burgess never had a updated resume until he sent the one for this case. And in this case, he said he was working on towards degree completion, when that was not accurate, because we heard reports that said he hadn't worked on anything towards degree completion for 2019. So you're telling me Brennan missed that, and yet he's going to go into this kind of deep dive questioning on something that's just a harmless, innocent, non-factor?
11 trials, 7 depositions, 18 testimonies total. Not sure if you want to clear it up or just leave it. Was that
Correct.
right?
Yes, sir.
Did you just leave it?
I'm not responsible for asking the question, sir.
He's not scoring any points here. He's just looking like a bully. Yep. I agree with you, Valerie D.
Do you ever heard the terms confirmation bias?
Yes.
Do you know what confirmation bias is generally?
Generally, yes.
Do you think that you suffer from any confirmation bias in this case?
No.
Do you have any close family that supports one side over the other? Not the facts of the data, but one side over the other.
Close family?
Yes.
Not that I'm aware of, no.
Wife?
My wife?
Look at wife. How the jurors were turned off by this. Watch what happens.
I don't really know what her thoughts are on the case.
May I approach?
Yes.
So now apparently he's going to bring up some Facebook post, but he doesn't do anything with it.
Take a look at that document. Have you seen that before?
No, I have not.
Never seen that.
No.
Take it back. You're unaware of anything that may influence you to lean one way or another?
This is unbelievable how he's just going to sit there and try to make this guy look like he's going to completely manipulate tests to try to help Karen Reed when he's going to jeopardize his career to help one client.
Correct.
When you first took a look at some of the facts in this case, you had some information. Since then, you've received a lot more, haven't you?
Correct, yes.
Part of your testimony today to this jury was to provide opinions that you do not think that the holes in Mr. O'Keefe's clothes are consistent with some type of collision. Is that fair to say?
Yes.
In coming to that opinion, you relied on some of your testing that we saw in those videos, didn't you?
Yes.
And that testing involves a hybrid 3-arm, doesn't it?
Correct, yes.
A hybrid 3-arm is an arm from a crash dummy.
Yes.
That's not the technical name, but that's what it's often referred to.
Yes.
And you and Dr. Renshaw have been working together on this case, haven't you?
Yes.
You've discussed ideas and shared thoughts.
Yes.
In fact, you've worked so intimately together, you know some of the things he's going to testify if he comes to testify, you've said many times today, right?
Yes.
And so some of the data that you've shared and some of the opinions overlap with each other, wouldn't you say?
Certainly, he's going to rely on a lot of that test data, yes.
When you were forming your opinion about holes in clothes and potential abrasions to somebody's skin, all of those tests, all of those that you did, were using a crash test dummy arm, weren't they?
Yes.
In your report, you cite, or Dr. Renshaw cites, 3 different sources regarding testing clothing and skin, correct?
I'm not sure.
Well, haven't you read his report?
I've skimmed it, but I don't know what the basis are for his opinions.
Did you see footnotes 24, 25, 26, 24 being skin tissue cutability and its relation to lacerations, severity, indices? Did you read that?
Let's see if there's a foundation.
No, I didn't read that reference.
Did you read 25, the book that is cited, Forensic Pathology, 2nd edition?
I'm going to have you come to sidebar.
He's asking about whether he read a book or not. And Burgess doesn't have a bachelor's, and he lied about it for looks like a decade. Unreal. All right, let me jump ahead here. Wasting more time.
Let me again ask you about this book that is cited in Dr.
So obviously the judge is going to allow it.
Renshaw's
Stupid book.
report. By the way, have you read Dr. Renshaw's report?
As I mentioned, I skimmed through it.
So in all of your preparation with Dr. Renshaw, you merely skimmed through his report? You didn't take time to read and study it?
Well, none of my opinions are based on work that he did. He's undertaking a completely separate aspect in the analysis.
But that's not the question. The question I asked
Look at that smart aleck response. That's not the question I asked.
you was, did you, in working closely with him, take the time to study his report?
He already answered it. And see, he's saying he's not answering it. And that right there is gaslighting the jury and this witness.
As I mentioned, I skimmed it. I didn't read through, as you mentioned, all the references or what he cited. I didn't do that.
Did you read his report?
I did read the report, yes, but I didn't in depth go through each reference and look at what he was citing.
So you read his report?
Yes.
And when you read his report, did you see there were footnotes for a number of different propositions that he made?
I know that there were footnotes in the report, yes.
Well, on the issue of whether or not crash test dummies should be used during experiments,
See, so he can bring up other people's, when Hank wants to, he can bring up other experts' opinions. But when Hank doesn't want any of the defense witnesses and their experts from bringing in other comparative experts' opinions, it gets blocked because the judge will rubber stamp it. Also, if the defense tries to bring up, like on Welcher, any other opinions, for example, for Trooper Paul, it gets blocked as well. So it's all reversible error. It's just
as
a
a
sham.
basis for an opinion of whether
Sham and
abrasions
scam.
can happen through cloth or an arm. Wouldn't that particularly interest you, since you were going to come here and testify about it multiple times in front of this jury?
I'm not sure I understand your question.
You knew you were going to come in here and suggest to the jury that you thought that these tests were inconsistent with causing any type of holes in clothing similar to Mr. O'Keefe's or abrasions on his arm. You knew that was going to be part of your opinion today, yes?
Yes,
And
yes.
as part of forming a valid opinion that people can rely upon, wouldn't you want to do as much study as possible on the background for that opinion before you give it to a jury?
Oh, you mean like Welcher? Welcher talked about cadavers, dropping cadavers on their heads. And that's not even admissible in civil trials. And it's considered unreliable by the medical community and the scientific community and the engineering community. So that's the kind of stuff you're talking about?
I suppose, yes.
Well, you suppose. Don't you think if you come in here as an expert, the jury is relying on your background and education?
Oh, you mean like Burgess, the one that you had him update his resume, but conveniently left out the fact that working towards his degree was not actually true, that he hadn't worked on it for 7 years, 6 or 7 years?
Don't you
Yes.
think- And they're relying on the fact that you're representing something definitively or with an opinion to a reasonable degree of certainty? You understand that, right?
Yes.
And don't you think when you do that,
It's just degrading and mockery of this witness. So he ought to get thrown out of the courtroom with a real judge. But you know what? I just got to try to stay calm because I know he's lost with a jury. The jury can't stand him, and he's not going to get a conviction on this case.
that it's important that you have proper study and foundation before you just come into court and give an opinion?
Well, I will note that the ATD crash.
Yeah, and your cops don't do anything of their homework to process a crime scene, and stuff is staged and broken and planted, and you're representing that as a legitimate process crime scene, and then you block the defense from bringing in retired FBI agent Easter. That's the kind of stuff you want the jury to be tricked on and hiding the ball from. So what a hypocrite.
is a generally accepted test device to use for not only assessing occupant forces in motor vehicle crashes, but also to assess impact forces. So that the use of that device is certainly generally accepted.
When you get uncomfortable with my question, Judge, you generally tend to answer a different question.
Sustain, Mr. Brennan, next question.
Oh, that's a strike.
Strike that, Jules.
Let me ask you again.
Doesn't mean anything.
As an expert, it's important when you come in and you're going to present an opinion based on science or engineering or whatever you want to do, that you study the basis for that opinion before you give it.
Yes.
When you saw in Dr. Rentel's report references to this very issue about what should be used when you're doing demonstrations or study of what can cause tears to clothing, weren't you interested in the basis for those opinions?
Well, again, it was something where Dr. Rentschler and I worked together, and we were in agreement that we could utilize the ATD arm clothed.
When you decided to have an agreement that you could use that arm, did you read the book that he cites as support, Forensic Pathology, 2nd edition, Vincent J. DeMaio? Did you read it?
No, I did not.
Did you brief it?
No,
Did you peruse through it at all?
no.
When you decided to come to this agreement that's going to have a foundation for your opinions, did you look at footnote 26, understanding the acute skin injury mechanism caused by player surface contact during soccer, a survey and systematic review? Did you review that?
No, sir.
Have you seen any articles that support the proposition that a hybrid 3 arm of a crash test dummy is appropriate to use when you're trying to provide a foundation for an opinion about whether or not tears can happen to clothing or abrasions to skin? Do you have any support for that in your report?
Well, again, Dr. Rentschler is going to be addressing the... You're shaking your head.
Multiple opinions.
So I'm going to let him answer the question first.
So he's shaking his head and he calls him out on it. That's good for Dr. Wolfe.
As I mentioned, Dr. Rentschler is assessing the injuries to the arm, okay? He indicated to me that we could utilize the hybrid arm to assess the injuries to the arm.
So you have no independent experience or research or knowledge, not Dr. Rentschler, you don't have any independent research or science or knowledge to support your idea, your theory, your opinion to this jury about the tears to the clothes into the skin.
I was relaying the observations from the testing that we conducted with the ATD. Ultimately, like I said, Dr. Rentschler, it's my understanding that he will testify to the abrasions or the lacerations to the arm.
You've given multiple opinions about this to this jury, didn't you?
Correct, yes.
I'll ask you one more time. I'll ask it this way. Name, other than someone called Dr. Rentschler, name the papers, the studies, the learned treatise, name the resource material you relied on as the basis for those opinions, that a hybrid 3 arm can be used in these type of demonstrations as a basis for that type of opinion.
I certainly, ATD crash test dummies can be used for impact testing, yes.
Not impact testing. You're talking about tears to clothes, abrasions to skin, and I'm asking for the 3rd time. Name one journal, one paper, one study that supports your proposition that you're relying on as the basis for your opinion in front of this jury today. Name one.
I did not cite any in my report, no.
Can you think of one that you didn't cite?
Not that I'm aware of, no.
There's probably not a test because there's nobody that'd be this stupid to think that these injuries would be derived from a vehicle strike, the injuries to John O'Keefe. So it's really such a absolute joke and farce that they're making this argument and they really think a jury is that easily bamboozled and tricked into believing their lies and all their gaslighting. Yeah.
You had mentioned on direct examination that when you first started looking at materials some time ago, at the beginning, you were unconstrained in the scope of your study. Is that fair to say?
Are we talking about 2023?
Yes, we are.
Okay, yes.
You are.
Well, hope abounds. You did not know that Brennan had helped Burgess update his resume. No, I'm deducing that. I'm not saying we have proof of that. I'm just saying if Burgess got away with never updating his resume, because think about it, the defense had put in numerous versions over the years that he's used, including a recent one he used in federal court that was not updated. And suddenly, in this case, is the first time he's going to put down that he's working towards a bachelor's degree. I think that only was because Hank would have asked him about those kind of detailed questions, because his bachelor's looked really screwy, because it talked about something general, then something specific, all in the same title. It wasn't like a major and a minor. So it's sort of like it was worded where the general and a minor, or a major and a minor, are all wrapped in one long title. So it looked hokey to begin with. So I think that Brennan knows that there was a bad resume out there. I just believe that, and I think that this updated resume with Burgess, that was still a lie, because he wasn't working towards recompletion. So don't know if I don't know if Brennan would have asked him, like, well, when's the last courses you took? But I really wish the defense would have honed in on that, and they didn't. They allowed the statement that he's still working and being enrolled in a degree program, when you cannot be continuously enrolled for 17 years on something and you still don't have a degree from it. They just don't allow that in any state university. Like he was saying, he was going to University of Alabama, Birmingham. So that's what I'm saying, is I think that it was updated because of questioning from Brennan.
Unconstrained, you could have done anything you wanted to.
Because think about it, he knew that Burgess was going to go up against guys with PhDs like Arca. So
I don't know about anything.
When you said unconstrained, what did that mean?
Well, the agency that retained us didn't ask us to do specific work per se, or specific tests.
You didn't do any type of crash test at that time, did you?
Not like was demonstrated today, no.
Instead, you started a working theory that perhaps a glass was thrown at the rear taillight of the defendant's car?
Yes.
Did someone suggest to you that was a theory?
No.
It's just something that you and Dr. Rentschler thought up together?
Based on the evidence that we had, yes.
When you thought up that as a potential theory, that's why you built the potato cannon?
The pressurized cannon, yes.
Pressurized cannon. And you shot a glass at the rear taillight, yes?
Yes.
You determined that
calls it potato cannon. Real classy dude.
at 37 miles per hour, there'd be similar damage?
Yes.
And then you came into court last year, didn't you?
Yes.
And you provided that opinion of consistency.
And you actually walked up the stairs of the courthouse and went through the front door, and you walked in the door of this courtroom, and you walked right up here and sat on this witness stand, didn't you? I mean, these kind of questions are so juvenile,
didn't you?
And abusive.
Yes.
You got up and you said that something to the effect that that speed is consistent with the damage?
Yes.
Now, when you gave that theory last year to the jury, did you...
Yeah, what allows him to talk about a jury? This was not supposed to be known. It was, everyone is supposed to keep it under wraps, that this is a trial that these folks had testified in before. Notice they were calling a proceeding, or when he testified under oath. And he just openly started talking about a jury trial and when he was on this cross-examination. So I guess he gets away with it, right? Because his mom's on the bench.
know about other evidence in this case? For example, if a glass was thrown at the back of the car, how would the bottom of the glass bounce off the car and land near Mr. O'Keefe's body?
Ask it differently.
Did you consider, when you came in last year and opined, gave your theory about a glass being thrown at the tail light was consistent with damage, did you think about how, if a glass was thrown at the rear tail light, the bottom would have bounced off the vehicle wherever it was and landed near Mr. O'Keefe's body?
I'm aware that it was found near his body, yes.
And knowing that it was found near his body, you knew his body was about 7 or 8 feet off the road, didn't you?
Yes.
Knowing the bottom of the glass, the broken glass was found near his body 7 to 8 feet off the road, did you consider, if somebody threw a glass and broke that taillight, cross your mind, how would the bottom of the glass bounce with him to where the body ended up?
No, I did not analyze that part of it.
If a glass was thrown and bounced off that car, would you consider how its legal would be left at the curb?
No, I did not
Probably.
evaluate that.
If glass was thrown at the car and broke the taillight, did you consider how the debris field would end up on the lawn?
Well, it's my understanding, I think that there were plows that came through that night, so I don't know that where the debris field was eventually found, if that's where it would have been at some point earlier.
Did you ever talk to Lieutenant O'Hara or anybody from the state police to see if the plows went all the way to the side of the yard or were just down the middle? Look into that at all?
No, I did not.
So did you give any careful consideration to if the glass was thrown and hit the back of that taillight, how would be a debris field on the front lawn of somebody's yard?
I don't think that was a part of our scope. It was more or less to determine whether or not, if the taillight was impacted by a projectile like a glass, could you get generally consistent damage to that taillight? That was the objective of the test.
So when you came in and testified last time, you weren't considering all of the other evidence that may not support that theory, were you?
I think our objective was to determine whether or not the damage was consistent with an interaction with Mr. John O'Keefe, and could there be another mechanism to cause the tail blight to break?
Is there a reason why you were backing off that opinion on direct examination today?
Sustained.
You weren't fully embracing that theory today, were you?
I'm going to
Slimy.
allow that.
I don't know if I agree with that.
In this case, you provided reports recently.
Yes.
When did you provide your report? Was it April 6th
April 6th?
or was it May 6th?
I think it's May 7th,
May
if I'm
7th.
not mistaken.
So you provided a report May 7th, yes?
Correct.
And do you know when this trial started?
Early April?
You provided your PowerPoint. When did you provide your PowerPoint?
I think it would have been Thursday of this week.
Well, it wasn't last night.
Sorry,
It's probably-
maybe Wednesday.
probably
Wednesday or Thursday.
Wednesday. Is that fair?
Yes.
In looking at pedestrian accidents, it's important to try, if you can, understand the exact positioning of the body, isn't it?
If a collision occurred, yes.
And if a collision occurred, you can't always identify the exact position of the body, can you?
No, oftentimes it can be very difficult, yes.
You would want to know if it is a collision between a car and a pedestrian, whether the person was fully impacted or it was a clipping type incident. Wouldn't you want to know that if you could?
That would certainly affect the trajectory, yes.
No, there's going to be a rebuttal by Hank Brennan. Hopefully it won't be drawn out for days on end.
You would want to know, if you could, the body posture, whether the person was standing up straight or crouching.
If there wasn't a strike, it doesn't matter where they found the body and all these kind of things, because there's no injuries to show that any part of the car struck John O'Keefe.
If a collision occurred, yes.
Whether they were turning or standing straight or they had their arm out. That's helpful information, isn't it?
It can be, but when we're talking about how quickly this impact duration is, right? If you recall back to the PowerPoint, right, we're talking about a 10 millisecond window. So however the body is positioned at contact, that's how it's positioned. It's not going to be able to have any significant movement or change in orientation in that 10 millisecond window.
The position of the body can change the trajectory of the person who's hit, can it?
They can't even show where the body was found, right? There's no markings, there's no details. They can't say exact number of feet from the curb, the exact number of feet from the flagpole. So, and here he is trying to bring this kind of questioning out on those kind of details when all that is just nothing but a blurred mess.
Sorry, can you repeat the question?
Positioning of the body, the way they're positioned, that can change the trajectory if they're hit after they hit.
It can, yes.
Whether they're moving towards the vehicle or away from it could affect the trajectory, couldn't it?
If they have some relative velocity, yeah.
Trying to determine the point of impact when you're looking at a scene, it's important when you do trajectory studies to know where the point of impact is, isn't it?
If you're going to utilize studies that look at projection of pedestrians when you're contacted at the center of gravity and you get projected some distance, you can rely on those studies, but you have to have an understanding of where the point of impact is and where the point of rest is.
If you don't have the point of impact, if you don't know the point of impact, you don't know the exact body position, that creates variables in your studies, doesn't it?
All right, the jury's just totally tuned out to Brennan here. He's just wasting his time. But it's actually good for the defense because the defense is solidifying their resolve to despise everything that comes out of Brennan's mouth.
Well, again, talking about those studies, they're not applicable when you are contacting, for instance, just a limb or you don't have a center of gravity hit. Those when you're talking about how far will a pedestrian get projected, if it's like a forward projection or what's known as like a wrap projection where the pedestrian wraps onto the hood and then becomes decoupled.
Yeah, he's doing a great job. Dr. Wolfe is able to keep his cool, act professional, and Hank's making a complete, utter fool out of himself.
Those studies are applicable there, but when you're talking about where there's minimal overlap between the body and the center of gravity, then you can't utilize those studies.
So you would not want to know where the point of impact is?
Doesn't matter.
In this particular case, no, I don't.
Your cops never bothered to locate that information, so now this guy's supposed to locate it?
I don't think it would be helpful.
You would not want to know the body position?
Doesn't matter if there wasn't
I don't
a
think
hit.
that it would be helpful in determining, because again, we have to start with, does the damage, is it consistent with a collision?
So you would not want to know the body position. That's what you're telling us. You don't want to know that.
Asked and answered.
Well, if the evidence indicates that the contact is inconsistent, then
Browbeating him.
that's kind of where the reconstruction stops. You can't go to a point of impact and a point of rest if there was no contact.
So you don't want to know the body position.
I mean, talk about harassing and browbeating and making a complete fool out of yourself. Unreal.
Can you answer that?
I don't understand this question, Your Honor.
When you're doing studies, you don't want to know the body position?
Can you answer that, Dr. Wolfe?
Again, it depends on the
Did you bring that out for Welcher? Welcher never said exactly where the body's at. None of your experts, none of your cops have said that. And now you're going to try to harass and harangue this guy over that? Insufferable.
type of impact. For the alleged contact in this case, you can't rely on those studies about impact location and point of rest. They're not applicable to
I'm not
this.
talking about studies. As far as data, information, you as the person doing tests, would you want to know the body positioning?
You know how many times he's asked the same question over and over again now? You tell me the jury doesn't pick up on this and think, unbelievable. Can somebody please shut this man up?
We'll get an answer, and that'll be it. We got an answer every single time. Can you answer that, Dr. Wolfe?
I feel like I've answered it the best I can, Your Honor.
Okay, next question.
You don't like that question?
What a smart aleck, guys. I'm sorry. This is no attorney would dare do that in a court of law. You get chewed out so bad by a judge. You're doing this in front of a jury. You're nothing but a punk, Brennan. You're nothing but a punk. Pulling this stunt in a court of law. Does anybody want to go to law school knowing that this kind of system exists in Massachusetts? Would you ever want to practice law in Massachusetts knowing you got this kind of corrupt behavior?
Strike. Jurors disregard.
Okay. When you were doing these video demonstrations, was it important to be as accurate as possible?
Yes.
Data changes if information changes, right?
I'm not sure I understand your
That's a
question.
tough question. You want to be precise as you can in ultimately having a conclusion regarding data, don't you?
Yes.
Could I have PowerPoint page 12, please? Now look at force on the bottom. The first letter F signifies force, correct?
Correct.
And the last two letters, MA, signifies mass, yes?
Correct.
That's a very important part of that equation, isn't it?
Yes.
If you change the mass, it can change the whole analysis, can't it?
I'm not sure I understand your question.
Let me make it more simple. When you did these tests, you chose a arm from a hybrid 3 crash dummy, didn't you?
Yes.
You can take that down, Ms. Gilman. Now, when you made that choice, you knew that John O'Keefe's arm, based on the statistics and his weight of being 216 pounds, you knew
You knew. He says that twice in one question. You see that?
that his arm weight would be 11.8 pounds, didn't you?
Yes.
And you knew that he was 6'1" tall.
Yes.
When you decided,
They don't know his weight of his arm. That was never done. They never measured his arm at the autopsy. Even then, it could be off because he was already dead for a number of hours. So the weight could have changed. It wasn't an exact weight of what he was when he was alive.
to choose an arm in this case, you didn't choose the arm closest to his weight, did you?
It was representative enough, yes.
It was representative enough.
It was close enough, yes, sir.
Close enough. Wouldn't you want to get an arm most closely related to his actual weight?
Oh, you mean like going 2 miles an hour is the best close analysis you can make for your expert welcher? 2 miles an hour when you're trying to say that John O'Keefe was struck going 24 miles an hour, Hank? Is that the kind of comparison you're talking about? Shame on you.
I don't know that you can have custom-made ATDs.
You probably can't custom make them, but they have one that's 12 pounds. You know that, don't you?
Are you referring to the 95th percentile?
Yes, I am.
Yes.
So there's a 12-pound arm. Mr. O'Keefe's is 11.86 according to the statistics. You know that, right?
Yes.
You looked it up.
Yes.
You didn't tell us that on direct, though, did you?
I don't believe I was asked that.
No. Instead of choosing the 12-pound arm, which is 0.12 difference, you chose a much lesser weight, didn't you?
It was about 10 pounds, yes.
No, it wasn't about 10 pounds. It was less than 10 pounds. Let's be exact. You're a scientist. Let's be as precise as possible when we're talking about data. It was less than 10 pounds, wasn't it?
I think according to the spec sheet, I think it's 9.4 pounds total.
How about 9.38? You keep coming up a little bit. 9.38 pounds.
Sustained in that form.
May I approach?
Yes.
Showing you a photograph.
It's abomination
That
already.
photograph of your materials in this case.
Yes.
And in that photograph, it shows the arm that you used in your studies, doesn't it?
Correct.
And it shows that that arm weighs 9.38 pounds, doesn't it?
Listen to his
Yes.
voice.
And that is less than the 11.86 pounds of Mr. O'Keefe's arm, yes?
Correct, yes.
You didn't put that photograph in your PowerPoint to make it clear to everybody you were using an arm that was a much lesser weight, were you?
No, I didn't put that photograph.
Can I move this to evidence, please?
Okay. Any objection, Mr. Jackson?
It wouldn't make any difference when you talk about those high speeds.
Give us a minute, let Madam Court Reporter mark it.
217.
Yes, now you can play it.
All gaslighting, folks. Trickery, deception. Oops, I lost myself. My phone hit the computer keyboard, so it knocked me off. Sorry about that. Where were we at here? Let's take a
automatically equal a pedestrian impact, right? We have to look at the evidence and the damage to the vehicle and the injuries to determine whether or not a collision occurred, not the visibility.
So you weren't trying to mislead the jury, you were trying to help them?
All right, I got to back up.
As I said, I wasn't involved specifically in that project, no.
And you mentioned that you did some stuff, or the company does some things for the NHL.
Yes.
You didn't tell us much more about what you
All
did.
right, I'm trying to find my spot here, folks. It's not showing me on the screen.
And don't you think when you do that, that it's important that you have proper study and foundation before you just come into court and give an opinion?
Well, I will note that the ATD crash dummy is a generally accepted test device to use for not only
this.
They're not applicable when you are contacting, for instance, just a limb or you don't have a center of gravity hit. Those when you're talking about how far will
Oh, I think I found it right
That
there.
equation, isn't it?
yes.
If you change the mass, it can change the whole analysis, can't it?
I'm not sure I understand your question.
Let me make it more simple. When you did these tests, you chose a arm from a hybrid 3 crash dummy, didn't you?
Yes.
You can take that down, Ms. Gilman.
Okay.
Now, when you that is arm to choose an arm in this case, you didn't choose the arm closest to his weight, did you?
It was representative enough, yes.
It was representative enough.
It was close enough, yes, sir.
Close enough. Wouldn't you want to get an arm most closely related
Right.
to his actual weight?
Here's where I talk about 2 miles an hour. Yep.
I don't know that you can have custom-made ATDs.
You probably can't custom make them, but they have one that's 12 pounds. You know that, don't you?
Are you referring to the 95th percentile?
Yes, I am.
Yes.
So there's a 12-pound arm. Mr. O'Keefe's is 11.86 according to the statistics. You know that, right?
Yes.
You looked it up.
Yes.
You didn't tell us that on direct, though, did you?
I don't believe I was asked that.
It wasn't necessary.
Instead of choosing the 12-pound arm, which is 0.12 difference, you chose a much lesser weight, didn't you?
It was about 10 pounds, yes.
It's not much lesser. So everything he's using as an adjective to describe stuff is absolutely spin city, mislead the jury, trick them, try to trick up and trip up the witness. This is so slimy. I can't stand to watch.
It wasn't about 10 pounds. It was less than 10 pounds. Let's be exact. You're a scientist. Let's be as precise as possible when we're talking about data. It was less than 10 pounds, wasn't it?
I think according to the spec sheet, I think it's 9.4 pounds total.
How about 9.38? You keep coming up a little bit. 9.38 pounds.
Sustained in that form.
May I approach?
Yes.
Showing
Hank can just make up any facts he wants and make witnesses for the defense try to adopt him. If not, he's trying to make it look like they're lying. So
you a
it doesn't work that
photograph.
way in a real court.
Is that a photograph of your materials in this case?
Yes.
And in that photograph, it shows the arm that you used in your studies, doesn't it?
Correct.
And it shows that that arm weighs 9.38 pounds, doesn't it?
Yes.
And that is less than the 11.86 pounds of Mr. O'Keefe's arm, yes?
Correct. Yes.
But that's not true. That's not the true weight of his arm. That wasn't weighed.
You didn't put that photograph in your PowerPoint to make it clear to everybody you were using an arm that was a much lesser weight, were you?
No, I didn't put that photograph.
I can move this to evidence, please.
Okay. Any objection, Mr. Jackson?
Court's permission, I'd like to show this to the jury.
Just give him some minute, let Madam Court Reporter mark it.
217.
Yes, now you can put it.
This is the arm that you used in all of your videos, right?
Correct. Yes.
And you can see, could you zoom in, Ms. Gilman, on the weight? 9.38 pounds.
Yes.
That's what the industry does for accident reconstruction. But you think you know better? Well, why didn't your blue man use this kind of testing there? That's what you're trying to do, is discredit this because you know your blue man wanted to take his money to the bank and didn't do any tests. That I could have done that test in 5 minutes, get some blue paint, slap it on a car, and then have somebody else back into me. That's all this guy did.
There's a bigger difference between 9.38 and 11.86 than there is 12 and 11.86.
That's
isn't
all
there?
you got.
Correct,
Nothing.
yes.
So when you do the math, and have you done the math before on this? When you do the math, it's 26% difference, isn't it?
Okay, why don't we do the math? Since he's talking about math, okay, 2%, 2 miles an hour versus 24 miles an hour. Can somebody do the math so I'm not taking time here? Do the math. What percentage difference is 2 miles an hour versus 24 miles an hour?
In terms of more force?
No, of mass, weight, 26% difference, right?
I'm going to trust you. Yeah,
Well, do you have a calculator?
I do.
Can you do it?
Sure.
Okay.
Yeah, what if he just said, I'm not comfortable with your tone when he's trying to verbally berate him like this, and then even looked to the judge and said, Your Honor, is this acceptable in your court of law? I wish folks would do that.
Before you do that, you took this from Mr. O'Keefe's 6'1". You used a crash test dummy that, what is the height on it?
Well, the ATD, I believe, is 5'7". The Rescue Randy, I think, is 6 feet tall.
We'll talk about the Rescue Randy later. We have questions about Randy. But let's talk about this. 5'9". You said 5'7". It's actually 5'9".
Sorry, 5'9", yes.
5'9". And it's 170 pounds?
171, I believe.
Mr. O'Keefe's not 170 pounds.
No, not his whole body.
He wasn't 5'9".
Correct.
Okay. So when you do the math and you take the 9.38 pounds based on the 171-pound doll, and you look at the percentage, doesn't it come out to 5.48% total body weight?
Yes.
Okay. And so the difference, when you look at it, it's a 26.3% difference from his actual weight, isn't it?
Correct, yes.
And so I'm probably at the 6th grade
Okay, 8%. That's 8% of it. So that's 92% off, and he's worried about 23%. Really?
level on this, but isn't it very basic that the more something weighs, the slower something has to go to have damage? And if something weighs less, the other part that collides with the force has to go faster?
The force is going to be greater if the mass is greater.
So if you throw a 5-pound rock into a window, you can throw it slower to cause the same damage as you have a 2-pound rock.
I don't know if I agree with that analogy.
So you agree that based on the 26% difference, in order to actually be accurate, to be specific, to be scientific, you then have to adjust the speeds that you presented on your demonstrations, and you have to reduce the speed by 26%.
I don't agree with that.
You don't agree with that. You think that having a lighter arm, so what you're telling us is having a lighter arm would cause the exact same amount of damage to the taillight studies as a heavier arm. Is that what you're telling us?
Well, if you look,
Exact same. Everything has to be exact same for the defense, but not for the Commonwealth. Isn't that nice, Mr. Brennan?
at, for instance, the 29-mile-an-hour impact test, that's significantly more kinetic energy. So the momentum of a 6,000-pound vehicle moving at 24 miles an hour, 29 miles an hour, that's going to overcome whatever the mass is that it's hitting at that point.
You're sidestepping my question.
Objection. Sustained. Ask a question, Mr. Brennan.
Bully.
Ask a question, no more.
My
comments.
question is,
Listen to his voice. My question is, I can't even stomach this
are
guy.
you telling us that
Are you telling us? I mean, it's just nasty slime ball type questioning.
having a lighter arm does not impact the
He's asked that over and over again. He just keeps on circular questioning the same stupid point that doesn't make any difference. He already said it doesn't make any difference, but the judge allows him to keep going on and on with it.
damage
Unreal.
in these tests as opposed to using the heavier arm?
Certainly not in the field test, no.
And so you disagree that when you look at the weights of those arms, do you disagree there's a 26.3% difference?
Yes.
You disagree.
No, I'm sorry, what was your question?
Do you agree there was a 26.3% difference in the arm weight that you used opposed to John O'Keefe?
Yes, the hybrid arm compared to Mr. O'Keefe's arm, yes.
And you are denying that there needs to be an adjustment to your calculation because the mass, MA, is different. You're denying that.
I think, again, if you're, and this is something Dr. Rensselaer, I believe, will
No, I want
touch
to talk
on.
to you. I don't want to talk to Dr. Rensselaer.
Well, because when you're addressing the
Look at the way he cuts him off, such a snot.
forces for injury and the mechanisms for injury, right, you would account for the difference in the weight.
So you're saying that it makes no difference that you use an arm that was 26% lighter. Is that what you're saying to us?
No, I don't think it would have made a significant difference, especially if you look at, for instance, if you're looking at the 95th percentile hand and the 50th percentile hand, they both weigh 1.25 pounds. They're the exact same weight. There's about a pound more roughly in the forearm and a pound more distributed in the upper arm.
That's not my question.
Sure.
It's not whether it's
Of course
significant
not.
or I'm asking you, are you saying under oath right now that the 26.3% difference had no impact on the calculations in that study?
Do you realize how many times we've been going over this over and over again? And this Brennan guy thinks he's scoring points with the jury. A good trial attorney knows you better score good points or move on. And he's just doing nothing but being a bully and a tyrant here.
It would have no impact at all.
Unreal.
The calculations, yes, but in terms of the damage, no, I don't think that 1 pound difference, when we're talking about something that's 6,000 pounds, striking something that's, quite frankly, whether it's 9.4 or it's 11 something, it's not, you're not going to get a difference in the damage.
So why not just have a 3-pound arm up there?
Well, I think that's unreasonable, sir.
What's that?
I think that's unreasonable.
What's the difference? It's a 6,000-pound car, according to you. What's the difference between 26% and 40%?
Well, I don't even know.
What a smart aleck here. You know, he's not able to distinguish anything that's intelligently bringing impeachment matters to what Dr. Wolfe has said.
Know that I agree with your percentage because, again, you're accounting for the whole part of the arm that goes up to here, which we did not strike that part.
It's, how much lighter? 2 pounds and what? How many ounces?
I just wish you would talk about this industry standard. This is what we use, things of that nature, to throw it back at Hank. Patrick, I agree. The more Brennan talks, the more the young jury turns against him.
Sorry, what was your
How
question?
much lighter is it, the arm that you used?
In terms of a percentage?
No, in terms of weight. The weight.
Yeah, that's a good point. Jennifer Rank saying, wow, they did test at 29 miles an hour to overcome any small details and definitely proved the taillight damage was inconsistent with the pedestrian hit. Well, and so if they're going even faster, then that's even more force against that arm that's 24% less. So yeah, they covered all their bases. So it's just smoke and mirrors. Brennan knows it's all smoke
Right.
and mirrors.
Mr. O'Keefe, 11.86, right?
It's just torture. You're right, Frida.
About 2.48.
And you're saying that makes no difference? None.
Not in the observed damage at those speeds, no.
Why didn't you use a 5-pound arm, sir?
I'm sorry, what was your question?
Why didn't you use a 5-pound arm?
Again, I don't know that they make a 5-pound ATD arm.
There you go.
You didn't tell us when you did these studies, you didn't disclose in your PowerPoint that you used an arm that was much lighter than Mr. O'Keefe's arm, did you?
It's not much lighter. And you don't know what the weight of O'Keefe's arm is. So all this is misleading and trickery.
I don't know that it was, I didn't give the weight in the presentation, no.
Look how long we've been going on the same goat rodeo, round and round and round and round. Okay, is it 16
Let's
times?
take a look at some of your testing.
Unbelievable.
The first one was at 10 miles per hour, test A. You remember that test, right?
Yes.
Now, 10 miles per hour, if you had taken 26% off, would you agree it would change the actual speed from 10 miles per hour to 7.67 miles per hour? If you did out the math, if you did it specifically, accurately, precisely, would you agree, using the wrong arm, you make the deductions and the calculations, that that 10 mile per hour test would actually be 7.67 miles per hour? Would you agree with that?
Oh, we don't allow that.
Of course.
No, because again, the arm is going to get accelerated up to that speed. So that the speed would still, that mass would still be accelerated up to 10 miles per hour. Same thing in the vehicle testing. It's going to be, given that weight difference, it's going to be accelerated up to that speed.
Now, can we see the video of test A, please?
That's true. League of his own.
Now, this is your study, 10 miles per hour, you claim, with a arm that is 9.38 pounds, correct?
Correct.
Mr. O'Keefe, 11.86 pounds, yes?
Yes.
Yes. Okay. Now, this light on the end of this, you're trying to replicate the light on the back of a Lexus?
Correct.
If a Lexus at 6,000 pounds hits a person, the Lexus isn't stopping automatically, is it?
No, it would move at a common velocity with the arm.
It would continue to push forward through the arm, yes?
It may, yes.
And the arm can push into the light before the body turns, yes?
I don't know that I agree with that, no.
If the light on the Lexus, not at this speed, but if the light on a Lexus was broken or breaks and it hits the arm, it's not going to bounce off the arm, it's going to push through, isn't it?
It's going to move at a common velocity with the arm.
And that will move not only the arm, it will move the person's body, won't it?
It may, yes.
It may push the body, it may throw the body.
Yeah, no, I would say I'm trying to keep this channel clean, so making comments about Dr. Wolfe's looks are taking up bandwidth for me to look. It's making my eyes harder to find legitimate questions. So please be respectful.
I don't know about throw.
Focus on
And
legal
the light,
aspects.
if broken, will continue to press against the arm until there's separation. Isn't that fair to say?
It could, in some instances, again, it could bounce.
It could, because it's not always the same. It's a dynamic process, isn't it?
It is dynamic,
You
yes.
could do the test many times and get very different results, couldn't you?
I don't know that I agree with that.
Would you get the same result every time?
I think you would certainly get similar results.
Every time.
If you had the exact same impact location and speeds, yes.
Well, that's my point. What if the impact location moved a little bit? Could it change?
Well, is Dr. Welcher changing? I don't know if, again, I was relying on what he provided
This
in
isn't
his
on
report.
Dr. Welcher. I'm asking you.
What a, my gosh, guys, this is, I've never seen such a, I got to bite my tongue here. This is unreal. This is
No, it's not.
unreal.
Okay,
That's all I can say.
so disregard that exchange between counsel. Next question.
If the body position changed, you may get a different result. Isn't that fair to say?
I was going after what Dr. Welcher had represented in his report analysis. So we did testing to analyze his orientation that he had demonstrated in his report.
You don't like that question either?
Sustained.
If the
I just,
body position changed, it could change the result. True?
jurors cannot stand this guy, Brennan, guys. I'm telling you, just keep your patience there because he's going to get a not guilty across the board. And that's going to be the jury's equalizer moment. Okay, I always call the jury the equalizer for all the corruption of the government. I've never seen something as corrupt as this Karen Reed case, and this is corruption beyond, way beyond anything I've ever seen. So the corruption I thought was bad. This is like takes the case because they're not even trying to hide the ball, and they're on worldwide coverage here, and they don't even care what fools they're making of themselves or how corrupt this process is. It's unbelievable. So just keep in mind that the jury's sick of it. The jury's sick of it just like we are.
I don't know what you mean by body position. Do you mean the whole body, the arm? What part of the body?
Okay, let's start with the arm. If the arm position changes, it could change the result.
You didn't have anybody change the position of the arm. You had your expert up there, Welcher. That's why I wish you would just talk about Welchers. We actually did the test that we saw Welcher do, and we're doing the exact replica of what you said happened. You said this happened. That's what Welcher testified to. This is exactly what happened. He actually made it sound as if there was no doubt. He didn't have to talk about whether it's consistent or not with hitting an arm. He actually got to say that it was John O'Keefe's arm, that this is the way it was hit. It was said a number of times, and the defense did not object. So shame on you, Brennan.
Well, I'm not aware of any other orientation that Dr. Welcher provided in his analysis report as to alternative orientations.
If the arm position changed, could it change the result?
So now you're arguing an alternative theory of what happened. If I was the defense, I'd slam them so hard on this on my closing.
Yes, I mean, I presume if you don't have your arm on the taillight, then yes, you'll probably get a different result.
What if it's bent in a different way? Could that change the result?
Again, I haven't reviewed anything that indicates that there was a different orientation that Dr. Welcher suggested.
You're a scientist, right? You can think. I'm asking you.
You can think, oh my gosh, guys, this is
Just a general question over here.
yeah, he's
If you
desperate.
bend
Okay.
the arm, could it change the result?
How many times can he ask this? I think the defense is just thinking, you know what? They are reading the jury. They can tell the jury's absolutely sick and disgusted with this mob lawyer.
It could.
Thank you.
Go ahead. You're winning in the trenches now, but you're losing the war, Brennan. You got the judge in your corner right now, but guess what? The judge will not decide the verdict in this case. The jury will. The jury's not your buddy. The jury's not your mama looking out for you. So let me back up here.
An orientation that Dr. Welcher suggested.
Watch this.
You're a scientist, right? You can think. I'm asking you. Just a general question over here. If you
Over here. He's looking at the slide, and he cannot keep himself respectable as an attorney. He's going to sit there and go, over here. We've seen him do that before. So
bend the
absolute.
arm, could it change the result?
I'm telling you what, I would say some jurors are ready to get up there and just choke Brennan right now. All right. That's how disgusting and sleazy and slimy this whole process is. Shame on you, Massachusetts. Nobody's stepping in, stopping this ugly, unconstitutional process.
Okay. When a pedestrian is struck, they are not held stationary on a harness, are they?
No.
In this case, the crash test dummy is on a harness,
Yes, he's supported.
strapped
Yes.
by its hips or pelvis.
Yes.
That's not real life. That's not how a pedestrian is usually when they're hit, right? They're not strapped to a harness, are they?
No, and again, the purpose of this test was to evaluate the arm. We're not looking at the whole body here with this test.
And when we talk about injuries, part of injuries is not just the impact, it's the drag, in this case, from the car, isn't it?
It could
It's all right. My phone
be,
hit.
yes.
But when you put the dummy on a harness, restricting or restraining its movement, it is not going to replicate hitting somebody and their movement, including the drag, is it?
I don't know that I agree with that, because it will replicate, again, when we're talking about that impact pulse of 10 milliseconds, it will replicate that. And that's ultimately what we're after, is what's happening in that 10 millisecond window in terms of the contact and the damage and the acceleration.
I know that's what you're after. What I'm asking you is, when you end it, when the light stops, unlike a Lexus, and the dummy is stationary, unlike a person, it affects the aftermath, the drag and the push after, doesn't it?
Yes, the kinematics would be different, likely, if it's not restrained like that.
In real life, the pedestrian usually is not restrained, are they?
Correct.
In real life, a 6,000-pound Lexus, upon contact with an arm, doesn't usually stop on a dime, does it?
No.
Could I have the
Well, none of the government witnesses could say when exactly Karen Reed's vehicle stopped after going 24 miles an hour.
photo from test A, please? And so there is no break, but there is a crack in this light that was a result of this experiment where this light hits that restrained dummy, yes?
Yes.
And this is at 10 miles per hour in your world, and 7.67 if you take off the 26% weight.
Stand us to that form.
We can move to test B, please.
All right, the strategy move has to be they can read that, just like we had the DUI guy reading the jury, and they're just so basically disgusted with Brennan, and they just stop taking notes, and they're shaking their heads at the way he's conducting himself with questions and objections. So they get it. They get it. So let him continue to be increasing the hatred and the disgust of the jurors. That's why they're probably letting this go on this bad.
Now this test B, a similar test, it has the same limitations, doesn't it? This dummy is restrained at the pelvis.
Yes.
Could you show the video, please? There's two videos. We can see the first one. And was the dummy restrained by its head as well?
Yes.
Was its arm restrained in any way?
It was tethered, but it was free to move.
This test you have at 17 miles per hour with the arm that's 9.38 pounds. Mr. O'Keefe, 11.86 pound arm. If you consider that 26% difference, wouldn't it be fair to say that this test, rather than replicate 17 miles per hour, would actually replicate 12.6 miles per hour?
No, can you answer that?
Not the way it's phrased, no.
And so looking at this test, test B, which you say is 17 miles per hour, can you do a calculation for the 26% difference, or is that something that you don't think is fair?
I don't think that'd be a fair way to characterize it. Again, if no matter what the mass is there, if you're accelerating it, if you're impacting at 17, that arm is going to move at 17.
Well, not just the movement, the damage. If this arm was 5 pounds, do you think the test would have the same exact result?
If it's 5 pounds,
Yes,
probably would be less damage.
it'd be less damage. So to get this amount of damage, you would have to increase the weight, right?
Sorry, what was your question?
To get this amount of damage, you couldn't use a 5-pound arm. There'd be less damage with a 5-pound arm.
Correct.
Right, because the less weight you use, the less damage at that speed. That's
Correct.
basically how it works.
Correct.
Okay. So, in this test, if we could run that back again, you have a restrained dummy at the hips and the head. There's no follow-through of the light or the body that's attached to that arm, correct? And at this speed, you can see the shards of taillight You can see them move, can't you?
When you say move, you mean just,
Not stationary.
yeah, I mean, they're moving from the taillight as they break.
Detached from the taillight.
Correct, they're
That
broken.
could create a debris field, yes?
Yes.
And you can see them floating in the air, some of them actually floating and then touching the sweater. Do you see that?
Possibly. Some of it might be, again, some of that polyurethane foam.
Yeah, some might be. And why don't we play it again so we can see clearly?
Well,
Some
it's all
might
that
be
foam
taillight shards
stuff.
too, right? That black object spinning, that's not poly foam, is it?
No, it would not be.
That'd be taillight shard, right?
Correct.
And so, even at this speed, you can see in this type of collision, there is significant, bless you, significant amount of taillight
Bless you, he
shards
says.
that are broken from the taillight and spewing into the air. Yes?
Well, I think on the one of the slides I had,
There's my phone again. Sorry, folks.
I think I showed the fragments that were left. And from what I recall, I think there was 4 pieces from the taillight, from the lens.
If you could put that back a little so Dr. Wolfe can see it again, to the point of the collision. Even at this speed, go ahead. Stop. You can see pieces, large, small, medium, maybe even microscopic, are now breaking off from that taillight and being littered into the air, aren't they?
Yes, there are pieces coming off.
If we can go to test C, please. Now, in test C, you actually use only an arm. Isn't that fair to say?
Correct.
You don't use a body or a crash test dummy.
No.
You don't, in fact, this is not the 12-pound arm either. This is the 9.38-pound arm.
Correct.
And when you do this test, you have the arm. It's basically just an object suspended in the air, isn't it?
Yes.
And you said, I think on direct examination, I think you said that this is the same as if it was on the dummy. Is that your testimony?
Well, in terms of, again, the amount of weight that would be interacting with the taillight, whether it's attached to the dummy or not, what's in direct contact is going to be the same.
Well, the fact that it's just floating up in the sky like that, it's very different than if it was attached to a person or a dummy, isn't it?
In terms of how it moves immediately after the impact, yes.
Not just how it moves, as far as the impact. Isn't it different?
I don't know that I agree with that.
Okay. Well, wouldn't you say that in addition to the arm, if you had another 200 plus pounds being held down by gravity, that would affect the force that's acting on the arm?
Well, the arm, again, is going to be accelerated, but the center of mass of the body is not going to see that acceleration.
Have you testified?
He hasn't done anything to impeach Dr. Wolfe here. Nothing. He's just spinning wheels, looking like a jerk.
Before in this case about the importance of the full body and gravity?
I'm sorry, what was your question?
Have you testified before in this case about the effect of gravity and the full force of a body as opposed to just an arm?
Yes.
Okay. And do you remember whether you thought it important on a previous time you testified that there was significance to the arm would be attached to a 200 plus pound body and there was the issue of gravity that would affect force?
From what I recall, I think that had to deal with whether or not the pedestrian would be projected based upon an interaction with the arm or a full-on center of gravity hit, right? When we're only hitting the arm, we're not hitting the CG of the body.
You did test B, and you claim it was at 17 miles per hour, test B,
Correct.
and we saw the damage. This is at 15 miles per hour, test C. Could you play this?
Oh,
please?
gaslighting.
might be a delay, so you could fast forward a little bit, please. How many times do you think that arm spun around?
I don't know.
That's not what would happen to a person who got hit. Their arm wouldn't spin through their body like that, would it?
Correct. It
Their
would
arm
not.
wouldn't spin that many times.
No.
There'd be the pull of their body weight, yes?
I'm sorry, what was your
They'd be
question?
But they have sensors so they can replicate similar to what a human being arm would be.
the pull of their body weight,
The body weight, yeah, would affect the movement afterwards, yes.
gravity, yes?
Yes.
Yeah. And so there's a reason why you do this test at 15 miles per hour. Is there a photo related to this, to the damage to the taillight? There is a reason why at 15 miles per hour the damage is much different than the other tests at 17 miles per hour, isn't there?
Correct.
Right, because at 17 miles per hour you have a dummy that is strapped by a harness in its pelvis, and when it's hitting the arm, it's affecting it much differently than just a arm floating in air. Yes?
No, I
I just want to say I understand Microdots is in the chats. Thanks for all the great work you guys do, or you as a person. I don't know how many are involved in creating these awesome videos, but you guys are the best, or you are the best.
I don't agree with that. The primary reason there's a difference in the damage is because of the amount of the arm that's outstretched and interacting with the taillights. There's a difference in those two tests.
And so the body and the weight of the body, you're saying, has nothing to do with the amount of damage.
Not in these tests, no.
So when somebody gets hit, does the body weight have anything to do with the damage? Not just the area that gets hit. Does the body weight affect it at all?
Not in terms of the impact, like the rest of the body, it's not going to matter if, for instance, only my hand, like in that last test we just saw, it was the hand and the wrist. How much my stomach weighs, my head weighs, is not going to affect the damage to that taillight and that interaction.
And by the way, this test, you said 15 miles per hour. If you consider the 26%, you're only at 11.1 miles per hour. Is that the right math?
Again, I don't agree with that, because if you look at the data and you integrate the acceleration data to get the speed, right, that we saw in those plots.
Yeah, everybody needs to make sure you subscribe to Microdots. I know there's a lot of new people on this channel. So make sure you go to Microdots. I think they have 2 different channels. And so you need to follow that to really help understand the details of this case.
The hand basically gets up to, I think it was 14 or 15 miles an hour. It reaches that common velocity of the vehicle.
Let's go to test F. On test F, you placed the dummy more behind the vehicle, didn't you?
Correct.
And when you test and you put it more behind the vehicle, this is more of a full impact than it is a clipping, isn't it?
Certainly, yes.
And when you
Hey, there is a Microdots video. Actually, I want to show that at the end of tonight. It's the one about the Lucky driving the snowplow truck to 34 Fairview. It's so high quality. So I want to jump to that here at the end of the coverage of this testimony.
put this dummy behind the car, this was not a legitimate crash test dummy. It was a different type of dummy, wasn't it?
Yes, it's called a Rescue Randy.
A Rescue Randy. And that is not typically the type of dummy that you're going to use for crash tests, is it?
I wouldn't agree with that.
And when you did the Rescue Randy and crash test F, did you use the 12-pound arm or did you stick with the 9.38?
The hybrid arm wasn't attached to the Rescue Randy. And
The hybrid arm was not. Is that what you said, or it was?
it was not. No, not in the full impact test.
Okay, so what was the weight of the arm on the Rescue Randy?
I don't know specifically the weight of the arm. I know that the total mass of the Rescue Randy was 200 pounds.
Isn't the weight of the arm important when you're talking about impact with the arm?
I don't think relative to the rest of the mass of the body.
So now the mass of the body counts, but before it didn't.
Sustained enough.
Okay. If we can see in test F, we have some photographs. Start with the first one, if you could widen that, please. Now, this is a direct hit.
Correct.
Is this simply a photo or a video? Could we go to the next one, please? So the rescue Randy's placed much further in the car than the other type of test.
So Brennan thinks by playing these videos, he's actually scoring points, but he's actually just digging himself a bigger hole because he doesn't have anything that's credible to impeach Dr. Wolfe on. It's just all trickery and spin.
That would be more similar to a clip, yes?
Correct.
Next photo, please. Okay. And that is the result of the impact.
Correct.
Do you see the debris field?
Yes.
Is it near rescue Randy?
Some of it is, yes.
Yeah, it's spread out a little bit, yes?
That's fair, yes.
But it's not right on his body. It's a distance from his body, yes?
There may be some, I can't tell from this photo, there may be some around his body, but yes, there's also debris close to the Lexus as well.
And could we, and this is the demonstration where you didn't turn on the videotape, so we don't have a videotape?
Correct, we had the false start, yep.
What's that?
We had the false start.
The false start. Is there another picture after this? Those clothes. Are there holes or tears in the clothes?
Yes, there's damage that's consistent with road rash when clothing or a body makes
Yeah, road rash, not like a dog bite,
contact with the pavement and is grinding
like John O'Keefe's hoodie looked like.
into the pavement.
Pavement's hard. Right?
Yes.
How about frozen ground, frozen dirt?
Is that
You mean a lawn? A lawn?
hard?
Yeah.
I suppose it can be.
Well, do you have any doubt whether frozen ground in the Northeast in the winter is hard? Hard as a rock?
Hard as a rock, really. A lawn with thick turf is going to be hard as a rock. Right there is gaslighting.
I haven't done any analysis to assess that.
And so seeing holes in those clothes is what you would expect after Randy hits that hard ground, right?
Are you talking about frozen grass or paved?
I'm talking about Randy right now. These holes in the clothes are what you would expect.
Frozen grass or pavement. Yeah, a lawn or pavement. It makes a big difference. But Brennan tries to make those things sound like they're the exact same. Like a rock, a lawn with green grass and dead grass on there that provides a big cushion barrier, even if the ground below is frozen.
After Randy hits the hard ground, correct?
Objection. I'm going to allow that. Is that what you'd expect?
Your Honor, I need a motion.
All right, jurors, feel free to stand up and stretch.
Yeah, Patrick, I agree. The arms weight will never be discussed because it's so irrelevant. Okay, let's jump ahead here.
So holes in the clothes is what you would expect after Randy hits the ground, yes?
If there is prolonged sliding contact with the asphalt, certainly you could expect to see tearing, large holes, material fraying, and even transfer of pavement material onto the clothing.
You've done no studies on hard ground like a front yard, have you?
Why didn't he say lawn? Ground makes it sound like it's bare, like there's nothing on it.
In terms of a pedestrian sliding on the grass,
In clothing tears, yes.
no, sir.
And if you could go back one slide. You see the debris field is near but not on Randy? Can you tell if there's any small pieces or microscopic pieces on or in Randy's clothes in the study? Did you look?
No.
I could go to test E, please. Test E, you cite as having a speed of 24 miles per hour, correct?
Correct.
And that's with a arm that is 9.38 pounds. Yes?
Correct.
And to remind you, Mr. O'Keefe's arm would be about 11.86 pounds. Yes?
Correct.
If you would reduce 26%, you'd be at 17.8 miles per hour, wouldn't you?
Objection.
Are you doing the math, Dr. Wolfe?
I don't agree with his characterization, Your
Okay,
Honor.
next question.
I understand you don't agree, but if you took 26% off the 24 miles per hour, you would come out to 17.8 miles per hour, wouldn't you?
I'm going to allow that. I'm going to allow that.
That's what the calculation would yield.
Okay. On test E, there are some differences between your test and what would happen in real life. For example, there is a harness, correct?
Correct.
And the harness prevents the dummy from being thrown naturally.
Correct.
The harness affects your ability or one's ability to see this study and see what the trajectory would be after impact, correct?
Well, that wasn't the purpose of the study, to assess the trajectory, sir.
I understand. I'm not trying to criticize, but it affects the ability to see the trajectory when the dummy's on a harness, doesn't it?
Yes.
Could we put up the first video on this, please? A photo 115, if we can start with. If you could stop it right there. And you can see the feet aren't as firmly planted on the ground as a person would be in most circumstances because of that harness, yes?
Correct.
And that affects gravity, doesn't it?
Affects gravity?
Well, when the car hits, the gravity, the weight of the dummy is less because it's held up by a harness, isn't it?
Right. So gravity really, again, is suspended at this point, just above the ground.
The arm that's extended, is there a glass in that hand?
No, there's not more weight in the hand.
So there's no object in the hand in any of these tests?
No, because ultimately what would happen is, because of the accelerometer being mounted on the palm of the hand, if you had a glass there, it would interfere with those measurements.
I understand why you didn't do it, but would you say it's fair to say that if a glass was in the dummy's hand on these tests, it could affect or change the damage?
Well, if you add another, I think that the drinking glass we utilized for the testing last year, I think was 0.7 pounds. So if you add another 0.7 or pound to the hand, that hand contacts the liftgate taillight, you certainly could see damage to that taillight, which we certainly didn't see on the subject vehicle.
So weight does kind of matter, right?
It can, yes.
Not just 0.7 pounds, the 2.5 pounds can matter too.
He's still talking about the weight difference. My gosh.
Weight matters.
Yes.
Because that's kind of what we were talking about for the last half hour. Weight matters in these tests.
Been more than that.
Correct, but you can't look at this in isolation, just between damage, and you can't separate it from the injuries, right? What's going to happen to the body in terms of the injuries in a 24-mile-an-hour impact?
Does weight matter?
In terms of the force?
And so we see
He's been asking this over and over again. It's longer than a half hour, and he's saying it's in half an hour. Do you realize how sick the jury is for this?
this dummy with the arm stretched out, correct?
Correct.
Okay, can we bring this back? Stop right there. This isn't approved crash test dummy, is it?
The Rescue Randy portion, no.
No.
It's not instrumented like a hybrid.
Is the arm the hybrid 3?
Yes, the arm is the hybrid
So
3.
you took, in test F, you didn't put the hybrid 3 on the Randy, but in this one you did?
No, because you risk, these AT devices can range from $100,000 to $150,000, and you run the risk of destroying that equipment in a test like that.
So in test F, did you put the hybrid on the Randy, or did you keep Randy's original arm
It's just the rescue Randy in the last test.
on F?
Correct.
This one, you have the hybrid arm on Randy.
Correct.
So you're switching up between tests what pieces you're using, aren't you?
I would say adding, but
Well, adding and subtracting doesn't have two arms. There's one off, one on. One's Randy and one's hybrid. So you're switching.
yes.
Different result.
I'm not sure I understand your question.
Okay.
Are you trying to say a different result between test F and this test? Because they're not the same test.
Oh, I understand. I understand. If we can have this come back a little bit more. Okay, and let it run. Stop. You can see the shattered taillight moving, and most of it's moving in the same direction, isn't it?
Yes.
And that's what creates a debris field after a collision, doesn't it?
Yes, I mean, components will break off and fall to the ground, yes.
Now, since Randy is on a harness, he's not going to be thrown the same way as it would happen in real life, is he?
Correct, and that wasn't the purpose of this
I
test, sir.
understand. When you chose 24 miles per hour without the 26% deduction, which would make it 17.8 miles per hour, when you chose 24 miles per hour, it's because you had looked at the tech stream data that had been taken from the defendant's Lexus, right?
Correct.
And when you looked at that data, you understood that during that event, 10 seconds of data is captured, yes?
Yes.
But that doesn't define the whole event, does it?
That only encompasses what was recorded.
And you said you chose 24 miles per hour because that was about the speed at the end of that 10 seconds.
Correct.
You do realize at the end of that 10 seconds, the car, the defendant's Lexus, was going faster. It was still accelerating, don't you?
Objection.
I'm going to allow it.
From what I recall, the last data point, I believe the throttle was still around 74%.
Well, ARCA specializes in tech stream data, don't they?
Yes.
Okay. So you are looking at that, you would agree that at the end of the 10 seconds, the defendant's Lexus was increasing
I think the jury's just like not even listening, is babbling on by Brennan.
in speed.
Well, we don't know, again, beyond that data point, what the data is.
At the end of that 10 seconds, the car was going up, not down, in speed, yes?
Correct.
And you can't tell how much longer that car traveled for after that 10 seconds, can you?
Correct. We don't know.
So when you chose the 24 miles per hour, it was just based on a data point. It wasn't based on you believing that there was an impact at a certain speed, was it?
No, and the triggering event itself it's not a collision by definition, and nowhere in that data can you parse out whether or not any contact even occurred.
We know that.
Okay.
The point is, you can't tell how
Arrogant.
fast the vehicle was going if it was in a collision from that data, can you?
So now he's trying to say you can't tell how fast the vehicle's going. So he's just, again, walking back his theory. What's going on here?
Sorry, can you repeat the question?
If that vehicle was in a collision, you wouldn't be able to tell from that data what the speed was at the time of the collision.
If contact allegedly occurred at some point in that data set, no, you would not be able to pick a row in that data and say, this is where the collision occurred.
Or after that data set, you would have no idea.
Outside of the data?
Yes.
No.
Okay. And so when you look at this experiment that you did, if you were to add, you said 24 miles per hour, but that's not considering the 26%. If you were to add 7 more miles per hour to this collision, would you expect more damage to that right taillight?
Potentially, yes, but you're certainly getting into the realm of injury at that point.
I'm not asking about that. I'm asking you a simple question about damage. If you were to add 7 miles per hour onto this test here, would you expect more damage to that right rear taillight?
Yes.
Okay, can you finish the video?
That'd be something. Yeah, if the jury says, you know what? Not guilty. All of us are leaving. Goodbye. Goodbye.
And I want to ask you some questions. You can stop there. I want to ask you some questions. Can you bring it back to right before the collision, please? Speed changes the
doing
result
nothing.
of this, doesn't it?
In terms of the impact speed?
Yes, the impact speed can change the result of this, of the damage to the right rear taillight, can it?
Correct.
And the angle of the arm can change the damage to that right rear taillight, can't it?
It can, yes.
Did you take any pictures of the debris field after the impact and damage in this test E? Did you take any photographs of the debris field?
The brief field has no relevance because if you can't prove the injuries to John O'Keefe's arm and the tail light does not cause those holes in this hoodie that John O'Keefe was wearing, then it's game over at that point.
I believe so, yes.
Was it included in your materials that you provided us?
It should have been in all of the test materials that was provided, yes.
Was the debris field within a certain range? Was it within a certain circle, 10, 20, 30 feet?
That sounds about right.
And so a debris field, although it might scatter, it almost forms kind of a ring, doesn't it?
It can, yes.
And it can form that ring away from where the body lands, can't it?
It can, yes.
And in this test, which you say is 24 miles per hour, without the reduction to 17.8 miles per hour, in this test, upon impact, there is a number of pieces of taillight that shatter, isn't there?
Yes.
Did you count how many?
About 19 pieces.
19 pieces. Could you move forward just a little bit? And when they break and scatter, some of them go up, some go down. Stop, please. Yes?
Correct, yes.
Some of them come in contact with Randy's arm. Yes?
Correct.
Now, Randy being on a harness, it's not.
I would say anybody that thinks Hank Brennan is a good lawyer is not seeing enough of this trial, or they don't know how juries view lawyers that act like this. So they have really no experience to go on. And if they think that you can be a bully and win cases and you're a good lawyer for doing that, he's very skilled at putting spin on facts and accusing people what he's doing and loading up trick questions and acting like a gaslighter, doing all this gaslighting. But that's not a good lawyer, folks. That is absolutely not a good lawyer. You have to have credibility. So are they going to say that this guy has credibility in front of this jury? So I think that what we have is the anti-Karen readers love to see this guy Brennan because he's their poster child of being a bully. They like seeing bullying in the courtroom, but you know what? If they were on the other side of bullying, they'd be the ones screaming out the loudest that this is like wrong, it's unconstitutional, and the judge and him are in cahoots, and they're railroading them. So it's fine when it's happening to somebody else, but you know, if it's happening to them, they'd have a completely different tone.
Like real life, when the Lexus goes by, could continue to push him with it, right? He can't go with the car or the Lexus because he's on a harness. Yes?
Correct. He's not going to move from that position.
If you can move forward, you see Randy's feet?
Yes.
See the right foot?
Yes.
It's twisting, right?
Correct.
Turning. Stop. Could you show the photo of the sneaker, please?
I mean, right now, I think, from my experience, I think the biggest thing that the jurors are going to talk about when they go back to deliberate is the corrupt behavior of Hank Brennan. They're going to be comparing notes. God, can you believe it when he did this? Can you believe it when he did this? Can you believe it when he asked Dr. Russell if she had a memory problem? They're going to be comparing notes and be talking about him for a long time.
When you were reaching your conclusions that you offered to the jury today, did you consider this photograph?
No.
Did you know that this sneaker was up against a curb in the area?
Yes.
And you didn't consider this at all?
Wasn't a part of my analysis.
Okay. You can go back to the video. You see the spin and rotation on the foot?
Yes.
Can you keep going? And the turn of the sneaker?
Yes.
Okay. I wanted you to go back.
Microdots, yes, I agree. I've said that Hank is actually making us so angry because him and the judge will do everything to destroy the constitutional rights of Karen Reed, but the jury is picking up on it. So in the end, Morrissey selecting Hank is the worst decision he made on trying to get Karen Reed convicted, because you cannot find a more hated prosecutor, and you can't win a case that way. Him acting this way is not going to win a jury over. And so if that's what you wanted, just to have someone to go up there and harass, harangue, browbeat Karen Reed's defense counsel and all the defense witnesses and shut down all the legitimate cross-examination, keep out the constitutionally required defense like Karen Reed should be able to present. And you know what? You still can't win. That shows what a loser case you guys got.
Ms. Gilman, please, to the point of impact. In your studies, you would agree there can be a clip of a pedestrian that causes significant damage to a taillight where the pedestrian incurs no lower body injuries whatsoever. That can happen, can it?
Well, I don't know that I would describe this as a clip to the arm. This is a full-on impact to the arm. So it's not a clip. Again, you saw it the 15 miles per hour. I think that's more analogous to a clip or a side swipe where the arm just kind of gets brushed out of the way. This, I would say, is a full-on impact to the arm.
Okay. To use your words, in a full-on impact like this, a pedestrian could be involved in a full-on impact causing that amount of damage to the taillight that's reflected in this video, but suffer no lower body injuries. Isn't that fair to say?
I don't address injuries, sir.
Well, let's play it forward. Do we ever see Randy's knees hit the car? Hips? Ribs?
Julie, you're saying Mark Bredero says Brennan is a good lawyer and I respect him, but I really think he's just choosing his words carefully in public. Yeah, I don't know why Mark would say that, because what kind of good lawyer? A good lawyer at hiding the truth? You're only a good lawyer hiding out the truth when you got a judge that completely shuts down constitutional rights of the defendant. So Brennan in front of a regular jury is an abomination. And he could not get away with all these stunts if he was in front of a regular judge in America. So this is a really skewed system here. Like I say, it's not a real court of law. It's more of a tribunal. A star
I see the
chamber
foot getting run over, but I don't think there was contact with the legs, no.
Would you agree that a pedestrian could be in this type of collision and suffer no lower body injuries based on your presentation here?
Sir, I don't address injuries. Biomechanics is not my area of specialty.
You said it's common in vehicle-pedestrian collisions that there is some type of bumper displacement. You
Correct.
said that?
Yes.
Okay, bring it back to the beginning, please. Stop. Any bumper displacement in this collision?
In this specific test, no.
You said that on direct, you would expect that there would be some panel deformation. What does that mean?
So if for instance, let's say the hand is not contacting the taillight or a portion of it is contacting the lift gate, you could see deformation to that body paneling.
You said that you would expect to see, not that you could. What you said on direct is you would expect to see panel deformation.
Yes.
And you said in this case there was none, right? Talking about the defendant's Lexus. You said, I would expect.
Hey, I just thought of this. You know what? Those of you that are following the first case, main case I've covered, which is the Adelson murder case in Tallahassee, Florida, where the Adelsons have been picked off one at a time for being prosecuted for the murder of FSU law professor Dan Markell. Who do you think's got a more whacked out theory, Charlie Adelson or the Commonwealth? I've said that Charlie Adelson has the most laughable joke theory I've ever seen for a defense of any criminal trial I've ever seen in my lifetime. And this one here is absolutely laughable as well. It lacks common sense. There's no science or physics behind it. What do you all think?
Expect to see panel deformation, and in this case, the defendant's Lexus, there was none. That's what you told us on direct.
Correct.
Let's watch let's watch your video. Play it ahead. Is there any panel deformation? Stop. In this?
No, sir.
Okay. So when you said on direct examination, relative to the defendant's Lexus, you would expect panel deformation, there was none. There are examples, one that you gave us yourself, where there is a collision causing this amount of damage to a taillight where there's no panel deformation.
I'm going to allow it.
Right?
If I recall, I think you're referring to my prior testimony in another proceeding where I had not conducted this testing yet. So ultimately, that's part of the reason why this testing was conducted, to evaluate that.
In this case, the damage to the right rear taillight, there's no panel deformation there, is there?
Correct, there is not.
When somebody is wearing a hat and they're involved in a collision similar to this, can their hat fall off?
Potentially.
Did you look at photos? Is there a photo of the hat, Ms. Gilman? Before you came to your opinions and conclusions, did you look at this photo and see a hat on the grass?
I did review this, yes.
And did you give any consideration
Oh, now he calls it grass. What about the hard ground, the rock-like ground?
when you did your tests to whether the hat would come off, Randy, or any crash test dummy when you hit it at that speed?
No, that wasn't a part of my evaluation.
Could I have photo 77, please?
Okay, we got 3 minutes left of this joke crossed.
What's that, sir?
So I don't know if you'll be able to see it in the photograph, but there was some material transfer from the jeans that the rescue Randy was wearing.
And so as a result of that impact, there was scuffing from Randy's jeans onto this exemplar Lexus.
There was scuffing, yes.
Did you look at the defendant's photos of the defendant's Lexus to see
Yes.
if there was a,
Sorry.
it's okay, to see if there was any scuffing in a very similar area?
I don't recall it being at that portion of the vehicle close to the rear wheel.
Where did you see the scuffing on the defendant's Lexus?
I think there was some scrapes along the wraparound section of the bumper cover.
The bottom part?
Correct.
It's not a claim that's attributed to the collision, so I don't want you to consider that. But did you see other scuffs a little higher up on the Lexus?
I did, but I don't know that those could certainly just be normal wear and tear to the vehicle.
Was that normal wear and tear?
This, no, because we observed it in the test.
Could I have photo 153, please? Now, this is a photo without the hatch back up. This is just the lighting fixture, right?
Correct.
And could you close up in on that? And you would agree if you went 7 miles per hour faster, it would cause more damage to that, wouldn't it?
Yes.
When the taillight is shattered and it spreads through the air, does it have the potential to impale a person, for example, on their nose?
Impale?
I'm sorry, can you repeat the question?
In your test, you saw that upon collision, there was a scattering of taillight that broke from the fixture, correct?
Okay, Karen said there was glass, not acrylic piece. She didn't say it was a taillight piece in John's nose.
Correct.
Would those shots
So he's trying to mislead again, trying to mischaracterize what Karen had said.
as they float or fly through the air, would they have the ability to impale a person on their face or even their nose?
I think that would be unlikely.
And finally, we've discussed,
Finally.
you now would agree with me that weight does matter, doesn't it?
It can if it's significant, yes.
I have no further questions.
All right, Mr.
Finally.
Jackson?
He scored no blows. No blows at all. Just made a complete fool out of himself. So let's go to the redirect by Jackson. It only lasts a little over about 14 minutes. So put it 125.
Yes.
Then I want to play that video of micro dots.
Can we, Dr. Wolfe, go back to your power? Do you have your PowerPoint
Yes.
set up?
Your Honor, may I?
Yes.
You have that ready?
Yes.
Can you go forward? And I don't have them memorized, so bear with me. Can you go forward to test E? And I'm going to ask you a couple of quick questions.
Okay.
Okay, if you could scroll through, keep going, if you'd please, to the next slide, the next. Can you, is this a video or is this a still photograph?
It is a video.
Is this at full speed or is this slow?
This is full speed.
Okay, can you go to the next slide? Okay, go back one. This is a test at what speed?
This is the Lexus moving in reverse at 24 miles an hour.
All right, let's go ahead and play this at full speed if we could. Dr. Wolfe, can you, that's awfully fast. Can you
Try
get
to-
to a point where you're moving frame by frame just at the point of contact?
Am I able to display my screen without doing the... Trying to see how I can get this to work.
If you could just move forward frame by frame rather than,
I don't know that I can in the... Oh, I missed it.
Okay. It may be more difficult than we thought. Let me ask you a couple of questions
Sure.
based on that. Did you review that video in slow motion as well as at full speed?
Yes, from a frame-by-frame perspective.
And in terms of a couple of different questions about that particular test, when there's impact with that right arm, what's the speed that the arm gets to upon impact?
In test E,
Right. If the car's going 24 miles an hour, what's the expected speed of the arm?
so the hand got up to a little over 24, the arm got a little over 21 miles per hour.
The debris that comes off of the taillight, the fragments, what speed would they be going at the point of impact when they crack and are...
This Lindy Lou I zapped because she called Dr. Wolfe a bozo and said he was relying on Welcher's testimony. Pretty ridiculous.
released from the taillight?
At the impact speed or less.
In order to penetrate the sweatshirt and cut the arm across, would the shards have to be going faster or slower than the arm?
They would have to be going faster. If they're moving at a common velocity with the arm relative to it, they would somehow have to accelerate with more speed to catch up and go beyond the arm, essentially.
Is that physically possible?
No.
I also want to ask you about do you have in your PowerPoint the photographs of the sweatshirt at the full, what you call the full-on impact, test F, as in Foxtrot?
I don't have any of those in the PowerPoint.
Okay. The photo that you showed, if I could ask Ms. Gilman to show the same photograph that she showed earlier of the subsequent to...
Wish you get closer to the mic.
Foxtrot with the holes in the sleeve,
If you can.
if she can.
Can you do that, Ms. Gilman?
Very kind.
Thank you.
Dr. Wolfe, you're shown just the left arm underneath the, whatever you call the dummy, Randy, right?
Yes.
Did Mr. Brennan show you the rest of the sweatshirt?
No.
What did the rest of the sweatshirt look like after this full-on impact when he was launched on the asphalt?
Mangled. So there was not only significant road rash to the clothing all over the torso section, the left arm, the right arm. There was holes.
I mean, everybody can tell that's what you'd get on your sleeve if you wiped out on a bike or slipped on a skateboard. Any kind of landing on pavement that we've all done as kids, that's what your shirt's going to look like.
In many different locations of various sizes. There was also just on the skin of the dummy, there was road rash on the face had been scraped. The torso had been scraped. So there was significant body damage to the torso as well.
Taking just the sweatshirt, separating that out. What about the bodice of the sweatshirt, the front of the sweatshirt? Were there holes and frays and damage to the front?
It was covered in all of those, yes.
What about the back of the sweatshirt?
I was just thinking, I was wondering if microdots could do something on Brennan. That would be really great to see.
That also have damage?
I don't believe the back, because I think he fell onto his stomach.
What about the other arm?
Yes, both arms did.
Were the holes and frays larger than the holes, the puncture holes that you saw on John O'Keefe's sweatshirt?
Certainly larger and again spread out amongst the entirety of the sweatshirt, at least on the front side.
Was the damage to the sweatshirt that you saw in this experiment consistent with the damage or defects that you saw in just the right arm, those 9 puncture holes on the right arm of the sweatshirt of John O'Keefe?
No, this is distinctly road rash. There's a clear distinction between the two.
Showing, looking at this particular set of defects in the arm, is that misleading in terms of its comparison to John O'Keefe's sweatshirt?
Sustained.
Your Honor, I'm going to ask to approach very briefly on an issue we discussed earlier.
All right, so they just got a few more minutes here, about 5 minutes. Let's jump ahead.
On cross-examination about some of the work that ARCA does on behalf of private lawyers, even insurance companies, correct?
Good.
Correct.
You were not hired by an insurance company. That's not who hired you on behalf of Ms. Reed or anything like that in the initial hire, correct?
Correct. It was not an insurance company.
Thank you.
So that agency that he mentioned, Dr. Wolfe mentioned, now they should realize it's not an insurance agency. Hopefully they'll get it that it was a federal agency, i.e. FBI.
A couple of more questions, if it's okay with the court, Your Honor, before we break.
Okay.
Thank you. You were asked several questions about the glass and whether or not the glass weighed in on your analysis of the damage to the rear tail light, correct?
Correct.
Did you consider that the glass on the rear bumper did not match the cocktail glass that was found close to John O'Keefe's body? Or were you aware of that?
I don't think initially I was aware that there was a difference between the glass cup that was found and the glass on the bumper.
You were asked a lot of questions about the difference in the weight of the arm. And I'm going by memory.
Well, here's somebody that's got a lot of insight. Emily M. Brennan just showed the defense on master class and cross-examination. Wolfe was systematically, logically broken down. Really? He looked like a completely biased and flawed expert. Okay, well, that's nice you think that, Emily, because obviously you're a plant for someone that's probably up there in Denham area, Norfolk County. So obviously you don't know anything about trial work. You've never seen what a real court of law would be like, and that Brennan is actually getting away with murder in this case. So if you think that was a good cross-examination, what points did he score on this guy? Did he get him concede anything? He deflected and answered everything back at Brennan. Brennan was just trying to be a bully. Do you like bullies, Emily? So you have a good night. Goodbye.
11.8 pounds statistically as it relates to Mr. O'Keefe versus 9.4 pounds. If I got that
Emily's
right?
gone.
Approximately, yes.
Okay. Are you aware that anybody has ever measured the weight of just John O'Keefe's right arm?
I'm not aware of that, no.
When you were asked questions about whether or not his arm weighed 11.8 pounds, are you ever aware of anybody ever weighing just his arm?
No,
What is that based on? 11.8, where'd that come from?
I don't know.
But you're going to mention the word statistic. Based on the statistics, his arm would weigh that much. Height, weight, etc.
Correct.
Does the statistic determine the actual weight of an arm?
No, not conclusive of what Mr. O'Keefe's arm weighed, no.
As you sit here, do you know whether his arm, John O'Keefe's right arm, if weighed by itself accurately, because pounds and apparently half pounds matter, if it weighed 11.8 pounds or if it weighed 9.4 pounds? Do you know?
I don't know, no.
Do you believe that your testing, the totality of your testing, was dependent upon those 2.5 pounds based on the weight of the hybrid 3, or at least the arm hybrid 3, and the statistic of 11.8 pounds?
Sustained.
In what way does that differentiation of 2.5 pounds or approximately 2.5 pounds, in what way does that make a difference in terms of your testing?
It doesn't, and that's part of the reason why we increase the speeds to almost 30 miles an hour to look at, again, when you're bringing that much more kinetic energy from the vehicle, that's going to overcome any mass that arm has. If it, like I said, if it's a pound difference, 2 pound difference, the momentum of that vehicle moving at 30 miles an hour versus 24 miles an hour, again, kinetic energy is equal to 1/2 times the mass times the velocity squared. So even if you go up a few miles per hour, you're exponentially increasing that amount of kinetic energy from the vehicle.
You were also asked a series of questions about reducing the speed of the testing by a certain percentage. Remember those questions?
Yes.
Did that make any sense to you mathematically?
Sustained enough one.
What effect, if you can tell us, well, let me ask it this way. Is the speed of the testing vehicle tethered in some way to the difference of that 2.5 pounds that Mr. Brennan was asking you about?
No, and again, as you saw throughout the PowerPoint, when that vehicle is coming in at 24 miles an hour, 29 miles an hour, at those speeds, that arm, when it makes contact, is going to get accelerated up to that velocity. It's just going to reach that common velocity. It's not going to, you're not going to somehow affect the vehicle speed due to that the fact that the arm weighing 10 pounds roughly, and you've got 6,000 pounds, it's not going to somehow scrub off speed of the vehicle.
Thank you. Your Honor, at this point, I would be going through a couple of photographs and videos that might be a good place to.
Okay, we understand this at every time. So we'll start today. Dr.
Look,
Wolfe,
she just gets up. The witness is still on the stand. I mean, this is so unprofessional. Unreal.
All right, jurors, one question I have for you. So
Leans
earlier,
over.
when we told you that Thursday would be a half a day. I'm told that we're nearing the end of this case, so I'd like you to think about whether you're able to stay all day next Thursday. Think about it over the weekend if you've made appointments or anything like that. I'm not asking you. But think about it, and on Monday, if you let Tony or Paul, whoever's with you Monday, if you have an issue with it, just let us know, and we'll do that. All right, so please do not discuss this case with anyone. Don't do any independent research.
Yeah, okay. So this is enough of this. Wow, this is hard to take, folks. All right, let me see here. There was one comment I want to respond to further back here. If I can find it. All right, I can't. The Super Millie. I'm a little disappointed they don't call Higgins and Proctor. So much information will be left out. They also got the momentum here, though. I understand you could bring in more details. I think they are worried about information overload. And if they can tell the jury's already discussed it with Brennan, then why make them be turned off by you? There's a thing called momentum, and so that's what I think is very much something that good trial attorneys read the jury, and if they know they already got it in the bag, they don't want to put on 100% of their case, even though they're leaving maybe 20% on the table that jury does not sing. So it's a calculated move. I would at least call Brian Albert, because I think the way he looks and the way he sounds on the stand is pretty sinister and scary looking. No, they're not going to call Proctor. All right, so I'm not finding this one comment here. It was something that was basically saying Hank was coming across bad, but he might have scored some points. Sorry, I don't see that at all. So anyway, let me go to the microdots. Let's check this out here. This is an awesome one. Check this out. There's Lucky. See how bright it is when you have snow? Any of you that lived where it's snowy out, it gets really bright out. Then you're going to have the lights, all those massive lights from that truck are going to be shining off the snow as well. Think about it, there really wasn't much snow on the ground at that time. Not even an inch. Not even an inch of snow was laying there when they were saying supposedly John O'Keefe was laying there. Think about all the people that were coming and going from that place between 12:20 and 2 in the morning. See those lights above the snowplow? Multiple lights. Yeah, Lucky's looking for animals and people and anything because he doesn't want to have a guilty conscience of hurting any living being. any living creature. So here it is coming on 34 Fairview. There's a mailbox. And right there, he's scanning, looking for things. Yeah, you telling me he wouldn't have noticed that? If you're looking for animals you're scanning,